I want to go a little early. That yesterday's Pathar matter, I pray that your lordship will take it up in the first half. That item 53,
You
order matter.
inform Mr.
In the first week or today, in the first half, lordship of that.
Please, I beg to mention item 14 and lordship. And this matter may be taken at 2 p.m. lordship. Item 14 and. Obliged.
My pleasure, sir. My lord, I am praying for listing a matter, my lord. Tomorrow it's already filed earlier, my lord. Some urgency is there, my lord.
What matter?
That is an anticipatory bail application. Your lordship has already allowed one co-accused to go on bail, my lord. So similar, my lord,
When have you filed?
I filed yesterday, my lord. Deeply obliged.
May I please, Your Lordship? I beg to mention item number 31. My senior is out of the station. So absent for the
Heard, Mr. What is your name?
Yes, Hussain on behalf of SHK.
Heard, Mr. S. Hussain, learned counsel for the petitioner who prays for an adjournment on the ground that his senior Mr. A. Saikya, with the conducting counsel in this case, is out of station. Considering the ground mentioned, the prayer is allowed. Let this matter be listed after a week. Is there any interim?
Yes,
The interim order shall continue till next.
Obliged.
may I please, Your Lordship? My lord, item number, my lord, 12 and 13, my lord. These are, my lord, as per my lord earlier observation, my lord, these are, my lord, partner matter, my lord. So, the matter may be taken up, my lord.
You apprehend that it may not reach.
Serially, my lord, may be taken up, my lord.
No, but it will, if we go serially, then we may, will it take time?
My lord, so far I am concerned, my lord, time may not taken, my lord, because it is a questioning matter. Time for informant.
This is not part heard. We'll take it up as the first item after finishing bail matter.
After finishing mail matter, my lord.
Because in this court, bail matters are to be
My lord.
given preference. After that, we will take it.
My lord.
May I please, Your Lordship, Lordship,
Oblige,
I
ma'am.
mention for listing criminal petition Lordship. Lordship, it is unlisted matter Lordship. It was fixed after Puja vacation, but not yet listed.
When do you want?
Next week, Lordship,
Okay.
28.
May I please, Your Lordship? My lord, I beg to mention item number 36, my lord. Here in this case, my lord, CD has not come, my lord. My lord, may I pray, my lord, let it be fixed after 15th December, my lord.
Heard Mr.
Hey, Manna.
A. Manna,
Manna.
learned counsel for the petitioner. Also heard Ms. S. H. Gora, learned additional public prosecutor, who prays for another date for producing the case. The prayer is allowed. Let this case be listed again on after 2 weeks.
After 2 weeks.
After 2 weeks, the interim order shall continue.
Obliged.
May I please? I beg to mention item number 38, my lord. Last time city was called perhaps my lord, city not available.
CD is not there, lordship.
Heard Mr. J. A. Ahmed, learned counsel for the petitioner. Also heard Ms. S. H. Gora, learned additional public prosecutor, who prays for another date for producing the case. The prayer is allowed. Let this matter be listed
12, lordship.
on 12th of this.
In time is there.
The interim order shall continue.
Obliged.
My pleasure, Lord. This is a 439 application, my lord. He was arrested on 26/7/2023 in a case registered under section 306.
26/7.
27, my lord. It is a succeeded case.
Okay.
Within period of 30 period, they have filed a succeed, my lord. It was lost by the in-laws, my lord. That is the next one page 10 is the FIR, my lord. My Sar Banu Begum, my lord. And marriage took place about 30 years back, my lord. It is not a recent marriage. They have got a son, 2 sons also, my lord. And actually, it is better relating to property dispute, my lord.
At what stage it is pending now?
Now the charges have been framed.
Charges are framed.
The charges are framed, my lord. Last date, my lord, nobody turned up, my lord. And matter was, and the court has rejected the plea on the ground that I may affect the prosecution case because I will win over the witnesses. We are not in good terms. There was a property dispute, some property in the name of my wife. But without him, they said,
Now, what was the basis of this observation by court?
their lordship will kindly see, sir. No basis, nothing, my lord. In the order sheet itself, it says 22-9, my lord. Bail of the page 30, my lord. In the bail petition is that since the charge is already submitted, therefore there is no chance of hampering and tampering by the accused will obey the order of court. The bail of the accused may affect the prosecution case, therefore bail is rejected. That is on 22-9. Again, my lord, your lordship may kindly see next page, my lord. That
How many days you are behind the bar?
I'm behind the bar more than I will complete 120 days on 26. Now I'm more than around 125 days.
Where is the last rejection on?
Last rejection, your lordship may kindly come to page 34, my lord. Running page 34, internal page 16, my lord. Since the bail application accused Allah Khan, the submitted accused is innocent since charge is already submitted. Therefore, no chance of hampering and tampering witnesses. There is a chance of influence of witnesses if the bail is allowed. How can it be, man?
So lordship possibilities are high because
My in-laws are there.
Brethren-
I don't have it. There is no complaint that I have.
No, there has to be some allegation that he tried to do something.
There is
yes.
no.
Let the witnesses be examined or the details.
There is not a, because he has rejected not on merit, on the ground that I will hamper the, I will
What is the-
threaten the witnesses, influence the witnesses.
We will impose condition not to.
Lordship.
Really, the condition meeting.
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedures, 1973, has been filed by the petitioner Muhammad Alad Chand, who has been detained behind the bar since 26/7/2023 in connection with Sessions Case number 213/2023 under section 306 of the Indian Penal Code. The learned counsel for the petitioner submits that the instant Sessions case is a result of an FIR filed by one Bhanu Begum on 10/7/2023 before the officer in charge of Baghbor Police Station, inter alia, alleging that the accused persons named in the FIR, including the present petitioner, had killed the daughter of the first informant and hanged her to the wooden frame. Stop. After completion of the said, on the basis of the said FIR, on the basis of the said FIR, Baghbor PS case number 42/23 was registered under section 302/34 of the Indian Penal Code. And thereafter investigation was initiated, and on completion of the investigation, charge sheet was laid against how many?
Again, this petitioner, his
Uh,
son and daughter-in-law, my lord, they were discharged.
Against the present petitioner only under section 306 of the Indian, no ingredient of 302.
No, it was especially as a result of it.
306 of the Indian Penal Code, and no ingredient of offense alleged offense under section 302 was found during investigation as alleged in the FIR. It is submitted by learned counsel for the petitioner that how many witnesses are there?
There in the list of witnesses, my lord, altogether, they have mentioned particularly 13 witnesses, my lord.
There are 13 listed witnesses in the charge sheet, and the petitioner has been detained behind the bar since more than 125 days. And the petitioner is a permanent resident of
Permanent resident of, my lord, village, Tedara, Pagbor, my lord. that is-
Borpeta district.
permanent resident of Borpeta district under the jurisdiction of the learned trial court, and he shall face trial. Learned learned counsel for the petitioner has also submitted that when the petitioner had approached learned trial court for bail, his prayer for bail was rejected on 9/11/2023 on the ground that there is a chance of influencing the witnesses of the accused. However, learned counsel for the petitioner submit that no ground for such an observation has been mentioned in the order by which his bail was rejected by the learned sessions court. Learned learned counsel for the petitioner has also submitted that the observation made by learned trial court while rejecting the bail does not have any basis on record. On the other hand, learned additional public prosecutor submits, what is your submission?
Lordship, let the relevant witnesses be examined.
Submits that he opposes the grant of bail to the petitioner at this stage, and submits that let the witnesses be that the prayer for bail of the present petitioner may be considered after examination of the witnesses. I have considered the submission and peruse the materials on record. There is no material. There are 13 witnesses listed in the charge sheet. And on 2 occasions, when the prayer for bail was rejected by prayer for bail of the present petitioner was rejected by the learned trial court, nothing was mentioned in the rejection order as to why it is apprehended that the present petitioner may threaten the witness. No material is available to suggest that the petitioner has ever attempted to threaten any listed witness. Hence, and considering the fact that the petitioner has been detained behind the bar since last more than 125 days, and he is ready and willing to face trial, his custodial detention does not appear to be necessary for fair completion of the trial of Sessions case number 213/23. In view of above, the petitioner, namely Alaa Chand, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Sessions Judge Borpeta, with following conditions: that the petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses in the charge sheet or any other person who may be acquainted with the facts of the case, so as to dissuade such person slash witnesses to depose against him in the pending trial in sessions case number 213/2023, that he shall cooperate in his trial and shall appear before learned trial court as and when so required by the trial court. With above observation, this bill applicable in this portion.
Noted. Obliged.
May I plead your lordship, this is a raid application 439. I was arrested on 26/10. Lordship, allegation in FR in page number 9. Lordship, may I read? To the officer inside.
376 charges are there.
Yes, Lordship.
Case diary would be required.
Lordship, but Lordship, may I read? Lordship, permitted me to read the FR, Lordship.
Yes.
Most respectfully, I beg to state that my marriage was solemnized around 14 years ago, and presently I am a mother of a boy child, Srimidul Adhikari, who is the inhabitant of our village, had established physical relationship with me and had also made an obscene video of mine by giving me various temptations from the year 2019. My husband came to know about the aforesaid incident. However, after discussion with the other person, I was allowed to continue my conjugal life. 6-7 months ago, the accused met me on the road and had shown me the above mentioned obscene video and further threatened me that if I don't continue to have physical relationship with him, he will kill my husband and my son and will make the said video go viral. He further told me to call him by using a small mobile and directed me to come to the garden at around 8-9 o'clock by taking the opportunity of absence of my husband, and it was there that he had physical relationship with me. I was sent to my parents' house when my husband came to know about the aforesaid incident. I was not able to speak about the aforementioned incident as I was scared. I have filed the present first information report against the accused when I thought the illegal act of the accused in my mother's house by which he had blackmail me and due to which my conjugal life is destroyed. As such, I pray to take appropriate actions may be taken against the accused. But the allegation is not true, Lordship. I and the informant lady are in love affair since 2019. And Lordship, I never forced her. The physical relationship which occurred between us was consensual, Lordship. And 376 40493 and 506 is not applicable in my case, Lordship.
No, but to examine that, we have to consider the
CD will be required.
case diary. But to verify your submission,
Yes.
so case diary would be required. Miss R. Kakoti, learned counsel for the petitioner, also heard Miss S.H. Bora. Considering the nature of allegations leveled against the present petitioner in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary fixing
812. Lordship.
812 for case.
Petition against my conviction of 3 months, 3 years, man. Two petitioner murdered, one already arrested, man. We filed 2 mistakes. Yeah.
In main revision petition, heard Mr. H.R.A. Chaudhary, learned counsel for the learned senior counsel for the revisionist, assisted by Mr.
Ayu Chaudhary.
I.U. Chaudhary, learned counsel for the petitioner. This revision petition has been
41.
filed under section 397/401
This section.
of the Code of Criminal Procedure 1973, read with section 482 of the said code, impugning the judgment and order
No, notice.
dated 4/10/2023 passed by learned session judge in criminal appeal number 3/2023, whereby the appeal preferred by the present petitioner against the order passed by learned additional chief judicial magistrate Sirang in PRC case number 99/2019 was dismissed. Stop. It is by the in PRC case number 99/2023
2019.
2019 by the order which was impugned before the first appellate court. The present petitioner was
Petitioners
the present petitioners were convicted under section 454
and PhD.
slash 34 of the Indian Penal Code and were sentenced to undergo simple imprisonment for
Yes.
3 years. Simple or rigorous imprisonment for 3 years. Rigorous
Rigorous.
imprisonment for 3 years. And to pay a fine of rupees 20,000 only. And in default of payment,
6 months,
6 months.
Lordship.
and in default of payment of fine to undergo simple imprisonment for 6 months. The petitioners were also convicted under section 380/34 of the Indian Penal Code and were sentenced to undergo
Same, my lord. 3 years.
Concurrently. 3 years, Lordship.
3 years.
undergo 3 years of rigorous imprisonment and to pay a fine of rupees
20,000.
20,000 in default to undergo simple imprisonment for 6 months. Issue notice to the respondents.
Respondent number 2.
As respondent number 1 is represented by, as learned additional public prosecutor has already accepted notice on behalf of respondent number 1. No formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
And
So
so in
are
the
you-
meantime, LCR may be called for.
Yes,
Okay.
let the
Appellate court, you know.
the case record of,
Scan copy.
no, we can call the,
LCR, Lordship.
let the case record, only appellate court record will,
That LCR have to return to the trial court, additional CGM.
let the
LCR.
case record of criminal appeal number 3/2023 be called for from the Court of Learned Sessions Judge Sirang, as well as case record of PRC case number 99/2019 be called for from the Court of Learned Additional Chief Judicial Magistrate Sirang.
Quite welcome.
The registry shall take steps for requisitioning the LCRs.
Yes, ma'am.
Yes, in IA,
Again, 1119 might have not arrested. The other one already arrested.
in IA, whether we have to hear the,
Not necessary.
Respondent.
Only, but actually part is not necessary. We made only POXO might have informant is necessary. Otherwise,
but you have made them.
and that way actually, might have, it is Taka also, might, I think. I asked her also, might, I think. Only POXO case might is maintained.
Now, what is your prayer to suspend the sentence?
Suspended sentence to remain on previous bail, so.
No, what, on what ground?
My lord, 3 years short period, my lord.
But this is after the appeal.
No,
this
that
is-
is there, my lord, but ultimately your lordship may exercise the power of 389 also. It is there, my lord, 401, CRP. 389 also, my lord, your lordship, 389, my lord, normally is 3 years already. Allowed, my lord.
No, I'm not clear. 389,
401 your kindness is here.
no, power is there in 397 also
Yeah.
to
Yeah,
suspend the
Your
execution of
lordship may
the.
exercise the power of 389 also, man. That is as per 401 says. ma'am.
But once you are found guilty after,
No, that is there, my lord, but normally, my lord, 389, normally your lordship, my lord, Supreme Court says short term period up to 7 years.
in 389, in
389.
while exercising appellate power, but here we are exercising revisional power.
But
This
401,
distinction
I'm
you have
just
to
saying
make
that
clear.
401. 401, High Court in the case of any proceeding, the court which has been called for by itself, the High Court may in its discretion exercise any of the power conferred on a court of appeal by section 386, 89, 392.
Okay, but no, but what, on what ground the,
Since revision is admitted, my lord, because ultimately the session judge did not appreciate any of it. First
okay,
appellate court, what to have done, my lord? Simple, yes, stated that, my.
that submission is there,
Yes, it is there.
yes.
Lordship, otherwise 389 subsection 2 of CRPC, Lordship. If
That is in the case of
in case of
first
10
up.
years,
Yes.
Lordship, and we filed written objection. Otherwise, but it is 3 years, Lordship, let him remain on the previous bail.
One, and the other one is my lord of the expert.
Heard,
Triple,
heard Mr. H.R.A.
the
Chaudhary,
lordship is taken 19.
heard Mr. H.R.A.
The
Chaudhary,
previous bail
learned
accepted.
senior counsel assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. This application has been made This interlocutory application has been registered on filing of an application by the applicant Jahirul Islam, praying for suspending the sentence imposed on him in PRC case number 99/2019 by the learned additional Chief Judicial Magistrate Sirang, by which learned additional Chief Judicial Magistrate Sirang stop. The applicant by the said order was sentenced to undergo vigorous imprisonment for 3 years under section 454/34 of the Indian Penal and was rigorous imprisonment for 3 years, as well as to pay a fine of ₹20,000, and in default of payment of fine to undergo simple imprisonment for 6 months under section 454/34 of the Indian Penal Code. He was sentenced to similar term of similarly for the offense under section
380.
380/34. The petitioner had preferred an appeal before the said order, said judgment before the learned sessions judge Sirang, by which was registered as criminal appeal number 3/23. However, said appeal was also dismissed by the learned sessions judge by order dated 4/10/2023. and the petitioner has now preferred a revision against the say order of the first appellate court before this court, and said revision has been registered as criminal revision petition number 499/2023. Learned counsel for the petitioner has submitted that learned trial court has not considered the evidence on record and has and what is the submission? Mr.
Madam,
Have not considered the evidence on record. What
yes,
else?
they appreciate the evidence.
And did not
First appellate
appreciate
court of
the
privacy.
evidence on record. Similarly, it is also submitted by learned counsel, senior counsel for the petitioner, that the first appellate court also erred in
Main counsel, without hearing the.
Uh,
notice to
erred in
proceed.
dismissing the appeal,
It will-
first appeal preferred by the present petitioner.
Yeah.
Learned counsel for the petitioner has submitted that there is a
Hmm.
ch- good scope, chance for
Okay,
getting
prior to the sales.
an acquittal in the, getting a verdict of acquittal in the present, in the connected revision petition filed by the present petitioner. And as the sentence imposed on the present petitioner is of a short duration of 3 years, unless the said sentence is suspended, there is a likelihood that the disposal of connected criminal petition would take a long time, and which would cause prejudice to the present petitioner if ultimately he is found to be,
Not found to be guilty.
if ultimately he is not found to be guilty of the offense for which he has been convicted. Stop. Learned additional public prosecutor also submits that considering the short period of duration for which the present petitioner has been convicted, and considering the probability of taking longer time for disposal of the connected revision petition, she does not oppose the grant of bail. She does not oppose the prayer for suspension of the sentence during the pendency of the connected revision petition. Having considered the considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, the sentence imposed on the present petitioner by judgment impugned by the impugned judgment
Dated 4/10/2020.
dated 4/10
Initially 36/23,
by the impugned judgment dated this has to be stated.
30
Impugned
original
judgment 36/2023
23.
passed by the Court of Learned Additional Chief Judicial Magistrate Sirang
Found by the session.
in PRC case number 99/2019 is hereby suspended during the pendency of the connected criminal revision petition number 499/2023, and the petitioner is allowed to remain on, you are on bail,
Let him go on first bail.
and petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned additional Chief Judicial Magistrate Sirang, Kajalgaon. With above observation, this interlocutory application is
Disposed.
in the second case, same order, name of the petitioner would be given.
Yeah, but he is arrested. You shall be allowed to be released on bail of rupees.
Same order would do. Name of the petitioner would be
Different lordship.
Safikul.
Safikul Ali.
Only
And
Rashid mentioned he has arrested.
Okay, that we need not to be mentioned because I have not stated any.
That will do. Obliged to.
May I please, Your Lordship?
Yes,
This petition filed under section 482, my lord, for questioning the FIR subsequent proceedings, which is pending in the additional CTM Kamrup Metro, my lord. Would you kindly state page 16 is FIR?
at what stage it is pending?
Is now, my lord, appearance stage, my lord. In the meantime, lordship, matter was compromised, my lord. Lordship, kindly see at page 37, my lord. Connector 6, my lord. May I read, my lord?
What is your name? Iqbal Hussain Borgu?
Iqbal Hussain Baruiya, my lord.
And who is Yasmina?
Yes, we have a private respondent, my lord, too, my lord. Accordingly, my lord, as per this agreement, my lord, she received, my lord, one-time settlement, lordship, kindly see at page 42, my lord. 7,50,000 she received, my
When the FIR was lodged?
lordship in the
After
year,
receiving or before receiving the?
after, before receiving. So problem is, my lord, petitioner is a army personnel, my lord. He is now working at Manipur, my lord. Lordship, kindly see it. I have stated the ground, my lord. He is now working at Manipur, my lord, very interior place, my lord. Now Manipur is a violent situation going on, my lord, between the ethnic violence, my lord, between the two parties, my lord, communities, my lord. Therefore, also he could not manage to leave, my lord. Very difficult to appear, my lord. Each and every day, he wrote a landed court below, my lord.
Then you file your prayer for dispensing with your personal, if that is the only ground.
My lord.
Yes,
Yes, at this stage notice should go to the respondent of it.
we are issuing notice.
And in the meantime, posting may be stayed. Otherwise, my lord, he could not, because lordship is army personnel, my lord, and he is presently working at Manipur, my lord. I have stated paragraph 7, my lord, in our petition, my lord. Paragraph 7, I have stated, my lord. Petitioner will to state at last after.
No, no, let me understand. On 20 February 2021, deed of compromise was entered into between you.
My lord.
Who is Yasmina? She is your wife.
He wife, my lord.
Presently also she is your wife.
No, no, my lord.
Has been divorced.
Yes, my lord.
Okay,
He received one-time settlement also.
okay.
7,50,000.
And after, when the FIR was lodged,
In the year 2020, my lord. Consequently, he has paid 16
Page
FIR.
16 is the FIR.
okay, okay. So the FIR was lodged prior to the
Yes,
settlement.
settlement.
Heard Mr. R.
JUNM, my lord.
Heard Mr. JUNM Loskar.
My lord.
Also heard Miss S.H. Bora. JUNM Loskar, learned counsel for the petitioner. Also heard Miss S.H. Bora, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Iqbal Hussain Borguia, praying for washing of the
Search it.
charge sheet number 3/2021, dated 31/2021, on the basis of which PRC case number 2396/2021 was registered and same is pending in the court of learned additional chief judicial magistrate, Kamrup. Learned counsel for the petitioner has submitted that the respondent number 2 was the wife of the present petitioner. However, matrimonial dispute occurred between them and thereafter they separated from each other. You have divorced.
Yes, my,
Where is this statement?
in this compromise petition also mentioned, my lord. Everything mentioned in compromise petition, my lord.
Where?
Deed of agreement is at page 37 and
Page
exit 6.
37, my lord.
And later on, they divorced from each other and on during the when the dispute occurred between the petitioner and respondent number 2, when the matrimonial dispute occurred between the petitioner and respondent number 2, the respondent number 2 lodged an FIR on 11/11/2020 against the present petitioner, alleging that she was the respondent, alleging therein that the respondent number 2 was subjected to cruelty by the present petitioner. And on the basis of the said FIR, Satgaon PS case number 185/2020 under section 498A/506 IPC was registered. However, thereafter, both the parties arrived at an amicable settlement amongst each other, and to that effect, a deed of agreement was also entered into between them on 20th day of January 2022. And as in pursuant to the said deed of agreement, the petitioner has also paid an one-time settlement amount of rupees 7,50,000 to the respondent number 2. However, in the meanwhile, the investigation in the FIR which was lodged by the respondent number 2 prior to arriving at this settlement with the present petitioner continued, and ultimately charge sheet was laid against the present petitioner under section 498A/506 IPC. Stop. Learned counsel for the petitioner has submitted that as the dispute between the petitioner and respondent number 2, who was erstwhile wife of the present petitioner, has already been amicably settled, there would be it would be futile to pursue the criminal prosecution which resulted which ensued as a result of the FIR which was filed by the respondent number 2 prior to their reaching settlement amongst each other. The learned counsel for the petitioners submits that the ends of justice requires it would be abuse of the process of court to continue with the criminal prosecution after a settlement has been reached between the party in a matrimonial dispute.
So far as Dr. May I submit, mutual divorce is concerned, that avowment is not made up. whether that has,
Okay, no, that he's submitting his
Yes.
submission.
but it is not.
Let us issue notice and
Yes, but
issue notice to the respondents as respondent number, as learned additional public prosecutor has appeared on for the respondent number 1. No formal notice need to be issued to the respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 1 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
Lordship, it should be respondent number 2, Lordship.
Sorry, respondent number 2, returnable within 4 weeks. However, in the meanwhile, as from the submissions made by learned counsel for the petitioner, as well as from the documents annexed along with the criminal petition, it appears that the dispute between the respondent number 2 and the present petitioner has already been amicably settled after lodging of the FIR by the respondent number 2. The further proceeding of PRC case number 2396/2021 is hereby stayed till the returnable date.
Returnable date, yes.
Much.
Nice.
The 482 for costing of the FIR and subsequent succeed now case is pending at the stage of the appearance of the executing officer and his evidence. What happened? The FIR was lodged in the year 2011. Charge sheet was filed on 29/10/2012. Thereafter, charges were framed on 17/11/2015.
Charges were also framed.
Yes,
Okay.
charge was framed against 6 persons. One person, so
No, you again, FIR was lodged on
FIR was lodged on
29/11/2011.
2011. And charge sheet was filed on 29/10/2012. And charges were framed on 17/11/2015. Fixing the case on 2/1/16 for evidence of the prosecution side. Thereafter, no prosecution witnesses stand up. Ultimately, charges were framed against the 6 persons.
including you.
Yes, including
Who is the petitioner?
petitioner, 2 persons,
Two.
Raju Ghosh and another Mantosh Pal.
Okay.
So charges were framed against 6 persons. One person was shown as absconder at the time of filing charge sheet. So case was split up against him. So trial proceeded against this 6 persons. But as no witnesses stand up, subsequently, one or two persons again absconder. They did not appear. Ultimately, on 8/4/2019, Lord will find at page 23, page number. Annexure 4, page 23. Accused Raju Ghosh and Mantosh Pal are present. The present petitioner hearing. PNA issued in respect of accused Chandrakanta Nath is returned after execution. Issue summon to the executing officer. Accused Chandan Giri and Ajoy Kumar Deo absent. PNA report awaited. For these 2 persons, executing officer's evidence was required to be he was required to be examined. And thereafter, 8/4/19 onwards, till date, case is fixed at the stage of evidence for executing officer. Neither executing officer appeared, and the case is since last 5 years, case is still at this stage.
The 13/5 order, the executing officer is present. He is examined in
Now,
respect
what
of.
is your grievance?
Grievance, I am appearing since last 5 years.
No, you pray for splitting up your case before the trial court.
So, Lordship,
At this stage.
kindly, there may be direction that will serve the purpose, to expedite the trial. I will file an application for split up the case, And that will be considered, my lord. And
Otherwise,
expedite the trial.
that is his alternative prayer.
Because this is not a
Alternative
ground for quashing.
And this is not
Yes.
because he will ultimately
why,
get
madam.
acquitted if since this is the case, he'll definitely get acquitted. And EO is examined, and his examination was found to be satisfactory, and PA report served. So at this belated stage, quashing, of course, will not be a.
That is why I am also not, my lord, insisting, my lord. My purpose will be served if the trial is
Expedited.
That order, okay, expedite.
Third, Mr. N.K. Kolita, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482, read with 482 of the Code of Criminal Procedure, 1973, has been filed by the present petitioner, by the petitioners, namely Raju Ghosh alias Bapan Ghosh and Montosh Pal, praying for quashing of the FIR dated 29/11/2011, on the basis of which Lumding PS case number 291/2011 under section 447/324/506/34 of the Indian Penal Code was registered.
And subsequently, my lord, 109 and 307 was added.
And after completion was registered, and subsequently section 109/307 of the Indian Penal Code was added thereto. And after completion of the investigation in the said case, charge sheet was laid against the present petitioners and 4 other accused persons. 4 others or total,
Well,
how many?
5 others.
Six. Very good.
Charge sheet was laid against 6%.
6%.
One person was shown as absconder.
4 other accused persons, including the charge sheet was laid as well as 4 others accused persons, showing one of the accused, one of the co-accused as an absconder in the charge sheet. It is submitted by learned counsel for the petitioner that though the FIR in this case was registered in the year on 29/11/2020, 2011, and the charge sheet was laid on 29/10/2012, and thereafter charges were framed against the present petitioners and 3 other. How many against how
4
many?
others, my lord. 4 others.
One was absconder.
Yes, my lord. Including absconder, it was 7.
Okay. So, Amita, charge sheet was laid against 7 numbers of accused. Now, what was the last name? Read only last word. Charges were framed against the present petitioners on 17/11/2015, and thereafter, though the case was fixed for examination of prosecution witnesses, not even a single witness has yet been examined, and in the meanwhile, some of the co-accused have again defaulted, and the case is pending for examination of the executing officers of the warrants of arrest issued against the absconding accused person. learned counsel for the petitioner submits that the petitioner is being harassed and he's facing you are continuously appearing.
Yes, madam.
He is continuously appearing before the learned trial court since the year 2012 after filing of the charge sheet. However, his case is, however, the trial of the case in case number.
Case
session-
number 259, my lord. I am mentioned it at case 23, lordship will find. Order. Session case 259 N of 2015.
Two 259 N/2015 has not progressed any further after framing of charges. Stop. Learned counsel for the petitioner has fairly submitted that though he has prayed in this instant criminal petition for quashing of the FIR and quashing of the charge sheet, however, even if a direction is issued for expediting the trial of the present petitioners, he would get the necessary relief. Learned additional public prosecutor also does not object to the said prayer. Stop. In view of the, I have considered the submissions made by learned counsel for the petitioners as well as learned additional public prosecutor. On perusal of the documents annexed along with the criminal petition, it appears that though the charges were framed against the present petitioner on 17/11/2015, that is about 8 years ago. However, since then, not even a single witness has been examined in the said trial by the prosecution side, only on the ground that the other co-accused, presence of other co-accused could not be procured, and a joint trial of all the accused persons against whom the charge sheet has been laid could not proceed any further. As from the documents annexed along with the criminal petition, it appears that the petitioners are regularly appearing before the learned trial court. This criminal petition is disposed of with an direction to the learned trial court to expedite the trial of the present petitioner, if required, by splitting up the case of the present petitioner from that of the absconding petitioners, and to dispose of the case of the present petitioner as early as possible. With above direction, this criminal petition is hereby disposed.
My lord, this is against the order passed on 1/8/2023 by the learned principal of family court. My lord, the petitioner before this honorable court is a headmaster, insult principal of a school, my lord. He got married with the response number 2 in the year 2008. But since the marriage, my lord, she picked up quarrel, my lord. As he didn't want to stay with his family members. Finding no alternative, he took a rented house. But from that rented house also, the landlord asked them to take it as because of her indiscipline and unsocial manner. Thereafter, again, he took another rented house. Thereafter, he took a plot of land, purchased a plot of land with the financial help of his brother, and a RCC house was constructed with the help of bank.
You are against the interim maintenance.
My lord, my lord.
That's an interlocutory order, no?
This is a 482.
This is, oh, sorry.
Against the order.
So let us
My lord,
issue
kindly
notice.
only,
yes.
I want to show, my lord, the annexure number 4 and 5.
Interim can be heard after she appears. Can be done.
No, what is your prayer now?
My
Do
prayer
you
is-
have any interim prayer?
He has.
Yes, my lord.
To stay the operation.
To stay the operation of the order, my lord. My lord, kindly see the annexure, my lord, 4 and 5, my lord.
At
Kindly
page?
see, my lord, page 23 is the FIR. Page 23, my lord. Kindly see the FIR. My lord, translated page 27, my lord.
You filed an FIR.
Yes, my lord. I have been driven out, my lord, after brutally, my lord, assaulted by the respondent number 2 and her relative, my lord. Kindly see the FIR, then, my lord. Page number, my lord, 31 will prove the torture, how she and her family members, physical torture meted out to me.
No, but this is a different aspect.
My lord, she has driven me out, my lord, from my house. Now I am in a rented house, my lord. She is not, my
What
lord,
do
she
you
is
do?
not entitled to any maintenance, my lord. She is not entitled, my lord.
That we will examine
A
after.
short date, dusty service.
Let her appear. Let her appear. Let her appear, then we will decide your interim prayer. We have to hear her story also. This is your story. She will have a different story that
Her story is that she filed, my lord.
let her tell her story
My lord,
herself.
in her case, my lord, she falsely stated that I have much agricultural land. I have much income from my agricultural produce, fishery, etc. But
Okay, we are issuing notice.
Not.
Issuing notice.
at least, my lord, for time being, my lord, the order may be stayed, my lord.
What's happening?
Not at the heard. What do you do?
I'm a headmaster, my lord.
Okay.
I have to, my lord, I have to give my lord my monthly, my lord. Kindly see the parasitic,
now.
my lord.
You are headmaster, that is enough at this stage.
But my lord, she has taken the house from forcefully, took my signature and taken my house, my lord, in lieu of Maharana, my lord. Kindly see also that, my lord.
We will examine everything.
My lord, kindly see her, my lord, kindly see, my lord, page 20. Kindly see page 20 and 19 is the, my lord, in the translated, my lord. Page, my lord. Kindly see, my lord, page 19 is the, my lord, translated from Assamese, my lord. She has taken my house also, my lord, and driven me out from my house.
Okay, we will consider your interim after service of notice of the respondent.
Till then, my lord, for time being, my lord, it may be, my lord, stayed, my
No,
lord.
this is maintenance allowance.
That I know, my lord, but she is not entitled to maintain because she has driven me out. I have not driven her out. She has driven me out. And that is, my lord, reflected in my FIR also, my lord. Even police asked me not to stay with her, my lord.
Heard Miss N.S. Thakuria, learned counsel for the petitioner. Also heard Miss S.H. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ruhul Amin, praying for setting aside the order dated 1/8/2023, passed by learned Principal Judge Family Court in FC Criminal Case number 306/2023, whereby the present petitioner has been directed to pay a interim monthly maintenance allowance of rupees 20,000 per month to the respondent number 2. Stop. Issue notice to the respondents. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from date of this order returnable. On you want a fixed date or after 3 weeks? After
After 2 weeks, my lord,
After-
this is not.
after 2 weeks. Stop. The prayer for interim relief of by the petitioner would be considered only after service of notice on the respondent.
Public.
My lord, in this case, both the informant and the accused were the student of JB Law College, and they fall into love, and there is some communication gap. They want to promise to marry each other, but there is some communication gap, and that is why the informant lost his affair. Now, presently, they have resolved their differences of mind. He lost his face 13 affair.
Settlement what? Settlement?
Page
Page 13.
thereafter.
Now, my lord, they,
Now,
they again,
where is the evidence that matter has been settled?
evidence is not there, but they are now,
Let a notice go.
Let
then
notice
the
go,
other party may come and say
my
that.
lord, in the meantime, I will protest it. She will come.
No, this is an anticipatory bail.
Yes, my lord. That is, I
Oh,
will
yes.
protest it. I will
I
appear
thought
with
it's-
IO. I will appear with IO. I will recover my statement. I made
is
the
an AP.
informant party. Notice go, she will come, she will.
It's an AP. I thought it's a criminal petition.
Yes,
In fact,
maybe.
423
The
says
affair shows that there was a love affair
that shows they were in a relationship.
in a relationship.
Now, they reunion. I make a statement here. I make a statement. Even still, she will
It
come.
is writ large. There was a relationship and they were all major. So I'll not object.
Mr. J. Ahmed Lanet Khan. J. Ahmed, no?
Yes,
Heard Mr. J. Ahmed Lanet, counsel for the petitioner. Also heard Ms. S. Jahan Lanet, additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Alamgir Ahmed, who is apprehending his arrest in connection with Gitanagar PS case number 230/23 under section 420/376 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 1/10/2023, the victim girl lodged an FIR before the officer in charge of Gitanagar Police Station, inter alia, alleging that both the victim as well as the petitioner are the student of JB Law College in Guwahati in the year since the year 2021, and they had developed a romantic relationship amongst themselves and
promise to marry her.
It is further alleged in the affair that the petitioner with promise to marry the informant had physical relationship with the informant and thereafter started blackmailing the informant. And now he has refused to marry the petitioner, refused to marry the informant. No. No dates are mentioned
No, that
when the offense
No,
occurred.
I think I'm married to your papa. Okay.
Learned counsel for the petitioner submits that both the informant and petitioners are the student of are adults and they had consensual romantic relationship amongst them. It is further submitted by learned counsel for the petitioner that due to some misunderstanding, there was a break in their relationship. However, later on, where is the paragraph where you have
paragraph 6, man.
however, what was that due to? And as a result of which the informant lodged an FIR against the present petitioner. However, the misunderstanding between them has been resolved by the intervention of their friends. And now by the intervention of the friends. Stop. It is also submitted by the learned counsel for the petitioner that as both the informant and the petitioner were adult, any relationship and the bare perusal of the affair would show that the relationship between them was of consensual nature. We can dispose it off.
Yes. Instead of interim and all.
Learned additional public prosecutor submits that the FIR itself shows that the petitioner and the informant were in a relationship and no specific dates of alleged offense are also mentioned in the FIR. It also shows she does not oppose the prayer for anticipatory bail by the present petitioner on the ground that this appears to be a consensual romantic relationship between two consenting adults. Stop. Considering the submissions made by learned counsel for the parties as well as materials available before this court is of considered opinion that custodial detention of the present petitioner does not appear to be, may not be necessary if he cooperates with the investigating officer or in fair completion of the investigation of which case?
Kitanagar
Itanagar PS case number 230/2023. Stop. In view of above, the petitioner, namely Alamgir Ahmed, is hereby directed to appear before the investigating officer of Gitanagar PS case number 230/2023 and cooperate in the investigation within 10 days from the date of this order. Stop. If it does so within the stipulated period of time, in the event of his arrest in connection with Gitanagar PS case number 230/2023, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following condition. That he shall not directly or indirectly make it threat or fraud, and he shall cooperate in the investigation. With above observation, this anticipatory bail application is thereby disposed.
Amla.
If please, Your Lordship, may I pray that the matter may be taken up at the some time.
Okay.
Yes, my lordship. Actually, bail application, there is bail application. My lord, the applicant before lordship is my lord, the driver. But because of the cruel took place between two businessmen, my lord, he unnecessarily dragged into this FIR. FIR is next page number 17, my lord. Now, the allegation is that because of my lord, some business rivalry took place between the parties, my lord, some physical injury caused to that informant. And there is a specific name mentioned, lordship, can see in 8 line. পিস মুহূর্তত উক্ত শ্রী বাবুল সেতিয়া মোক দাওয়েৰে আক্ৰমণ কৰে. There is no allegation against me. 8 line number 8. Babul Setia is different. I am Sri Jainath.
What is your name?
Jainath.
Jayaprakash Nath.
Jayaprakash Nath. Now, lordship, specific took a plea in paragraph 6 that at the time of incident I was not there, my lord. I made the statement in affidavit, my lord. Paragraph 6 of petition, my lord. Now, there is a quarrel between two businessmen, my lord. My name unnecessarily has been dragged there.
Between whom? Between Ranjan Borwa and?
My lord, Ranjit Borwa and my lord, Babul Setia. These are, my lord, sand lifter, my lord. And some might be dispute there, my lord. Therefore, my name has also been dragged, my lord. Lord, see what I pray at this moment, my lord, because, my lord, my statement is necessary at this moment. Whether I was there or not, or, my lord, is anything, suppose, allegation against me in their hand, my lord. Therefore, Lord, I pray that my statement can be allowed to be recorded. Only little protection may kindly be given to me, my lord. Lord, I'm a daily wage earner, my lord. Unnecessarily, I'm sitting in my house, my lord. My family are being affected, my lord, because of this whole incident.
Otherwise, his name appears in the FIR, Joynath. And of course, the overtact was stated only in respect of Babul Chettiya. But then later on, Lordship will see, he said, they will include Joynath also. I mean, I'm able to save my hands and all that. I fled away with my friend. Afterwards, no, I with my friend somehow fled away from and that point of time, they also shouted that they will kill us wherever we will remain. This day will, of course, include Joynath.
No, that my name is there. I'm not denying, my lord. What I'm saying, my lord, that my basic stand is that at that point of time, I was not there. Therefore, my statement is necessary to let the update CTP come, my lord. Without my statement, definitely my city will not serve any good purpose, madam. That's why a little protection, only 1 week, madam.
Otherwise, 506.
If 13, 14 stitches, so 506 will definitely come. And injuries were also severe.
My lord, city will reveal, my lord, that whether, because grievous is a very common word that is we used to make it a non-bailable, my lord, 26. That matters must be there, my lord. And my statement is very necessary, my lord. If suppose I would not be there, my lord, then, my lord, I have nothing to do in this subject.
No. Just a minute. Yes, this specific allegation are against Babul Setia
Babul
Babul
Setia
Setia
specific.
assaulted him.
Huh.
with
He
a-
was the one. But then one line that they shouted that they will kill us after like they were trying to fleeing
T26
out.
will not come to my side,
Yeah.
my lord.
So only here Joynath's name might come. I leave it to your lordship.
Or Mr. S. Samaria, learned counsel for the petitioner. Also heard Miss S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Joy Prakash Nath, who is apprehending his arrest in connection with Bare Kuri PS case number 21/2023 under section 341/326/307/506/34 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 19/11/2023, one Ranjan Barua within bracket Munu had lodged an FIR before the officer in charge of Barekuri police station, inter alia, alleging that on 8/9/2023, when the informant was busy in filling up sand in a dumper at village Atigar Gaon, the accused persons named in the two numbers of accused persons named in the FIR, namely one Babul Sutia and the present petitioner, arrived there and started assaulting the first informant. It is also alleged in the FIR that the accused Babul Sutia attacked the first informant with a dao, due to which the informant sustained injuries on his left hand. Stop. It is further alleged in the FIR. At the time thereafter, it is further alleged in the FIR that somehow the informant saved himself. However, the accused persons named in the FIR shouted at him and threatened him that they would kill him. Stop. Learned counsel for the petitioner submits that in this case, this case arose because of rivalry between two businessmen, namely the petitioner Ranjan Barua and the another co-accused Babul Setia. That though the petitioner has been named in the FIR, however, in the FIR, the specific allegations of assault by Dao has been made only against Babul Setia. It is also alleged it is also submitted that the petitioner is innocent and no way involved in the alleged offense. And in fact, on the date of the offense alleged in the FIR, he was not present at the place where the occurrence of where the offense is alleged to have been occurred. Stop. On the other hand, an additional public prosecutor submits that perusal of the case diary along with the medical report would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
Lordship, if your lordship is giving
interim
allowed. Then December last, 22nd of December.
fixing 22nd December for case diary. In the meanwhile, the petitioner, considering the fact that in the FIR specific allegation of assault by Dao has been made only against the co-accused and no such allegations has been leveled against the present petitioner, comma, he is hereby directed to appear before the investigating officer of Barekuri PS case number 21/23 within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Barekuri PS case number 21/23, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of the arresting authority with following conditions. Condition number 1 and 2. You will not intimidate witnesses.
Absolutely.
And
I'm a
will
small
cooperate.
business driver, my lord.
Let the case be
I
listed
have to look
again
my
on
family, my
22nd of December.
22nd of
deeply.
December.
Lordship.
Wait, please, your lordship. Lordship, this is a 438 bail application, lordship. Here the petitioner is lordship Tuzamil Hawk, lordship. FIR lordship will find on page 13, lordship. There are lordship as many as 31 accused mentioned in the FIR, lordship. And this petitioner is serial number 11. That lordship will find on page 13, lordship. Now, lordship, the relevant portion started from page 14, lordship, bottom part.
Somebody died.
Yes, lordship. May I read the lordship, the FIR, lordship?
How many persons died?
One person, lordship. One person.
Case
has been-
diary may be required perhaps.
Is very required. Of course, the case is under 149, common object. And the specific act is only against one Hanif Ali.
Hannibal.
Okay.
So all these are inside because of 149. 149 again, common object is difficult to deduce.
Who is before this? Who is the
This
petitioner?
serial number 11,
11.
Tozammil Haq.
Is there any allegation against him?
Tozammil
That
Haq.
is not specific in the FIR, lordship. Nothing against this, lordship.
Only Hanif Ali there is allegation. And then all of them came. What you will see after hearing got agitated, attacked him. Came forward. Then the accused person assaulted.
Now, lordship, here, lordship, what happened? The charge sheet has been submitted, lordship, and
Charge
showing
sheet
the,
has been late.
yes, lordship,
Right.
charge sheet has been laid, lordship, showing this petitioner as an absconder, lordship. Charge sheet has been submitted against lordship 11%. That lordship will find on page 19, lordship.
তাতে নোট করা নাই নেবে এবি
Page 19, lordship. And here, lordship, the petitioner, the relevant portion on page 25, lordship will find on the lordship paragraph number 1, 2, 3, 4. 4, lordship. Page 25.
Now, what has happened to Hanif Ali?
Hanif Ali expired. Hanif
No.
Ali.
No. The main assailant.
No, no. Yes.
Hanif Ali is also charged sheeted.
Now, whether he has been arrested or not, nobody.
Arrested. Hanif Ali was there.
Who out of these, the named accused persons, how many are behind the bar?
Lordship there.
Bilal Hussain, I think, no.
Okay. You show me the charge sheet, what you were.
That is on page 29, Lord. Page 19, Lord.
Yes, you were showing something.
Hmm.
You were taking me to some.
Yes, Lordship, this petitioner has been shown as an absconder, Lordship. That is on page 25, Lordship, paragraph 4, Lordship. So I beg to send them up for face their trial before the honorable court under the aforesaid section of law by showing absconder the accused, namely Anwar Hussain, Asraful Hussain, and Tazimul Haq. This is the present petitioner with a prayer to issue PNA and warrant of arrest against them.
Then what the trial court did?
Yes, Lordship, the page 57 is the trial court order, Lordship.
Page 57.
Yes, Lordship, it's a CGM court, additional CGM order, Lordship. Although he has no power to, Lordship, try this matter, Lordship.
Committal court, that is the
Yeah, committal court, Lordship.
it issued. Where is the order?
That is on page 57, Lordship.
It issued summons to you.
Yes, Lordship. Someone, but Lordship, this petition has been shown as an absconder, Lordship. When Lordship, their IO has made in prior Lordship, section 41 say, Lordship, CRPC Lordship, I have, after filing of the charge sheet, Lordship, it is not that, Lordship, there is a bar to arrest this petitioner, Lordship. Because he has been, IO has been made in prior to declare him as an absconder. That is the prior, Lordship. There is a apprehension every moment, Lordship, he may be, Lordship, arrested and to Lordship produce him before the CGM, Lordship. That court has no power, Lordship, until committal court, Lordship. Committal court has no power to deal with the matter, Lordship. It has to send the section, Lordship. Until unless, Lordship, it is committed, Lordship, he has to remain in the jail, Lordship. That is the apprehension, Lordship.
Since no overt act and no specific act, because 149 Lordship knows that even spectators sometimes get involved. Of course, what police have stated that they have, police have discharged few and charged few. I think out of 31, police have charged only 10 or so. 11. And Tuzammil Haq is one but last name.
Heard Mr.
Actually,
P. Chaudhary. Also heard Ms. S. Jahan, learned additional, B. Chaudhary, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Tuzammil Haq, who is apprehending his arrest in connection with, who is apprehending his detention in connection with PRC case number 2306/23, which is pending before the Court of Learned Additional Chief Judicial Magistrate Borpeta. It is submitted by learned counsel for the petitioner that on the basis of an FIR which was lodged by one
Safiqul Islam.
Safiqul Islam on 29/3/2023 before the officer in charge of Kosumara Police Station, inter alia, alleging that 31 numbers of accused persons named in the FIR trespassed into the land of Hanif Ali and assaulted Hanif Ali and others. No,
Lordship, Azizul Haq, Lordship. Azizul Haq was assaulted.
Is the deceased.
Yeah, this is. Page 15, Lordship.
assaulted, but they trespassed into the land of Hanif Ali.
Yes, Lordship.
And who was assaulted?
Azizul Haq, Lordship. Azizul Haq succumbed to injury, Lordship.
Because Azizul Haq and all, they were working in the field. I, along with my elder brother Azizul Haq, were cultivating. Land belongs to Hanif Ali.
It is also alleged in the FIR that at that time, the first informant, along with his brother Azizul Haq, were cultivating in their own land. And at that time, the accused persons named in the FIR assaulted them. It is specifically alleged in the FIR that accused Hanif Ali assaulted Azizul with a sharp weapon, as a result of which Azizul sustained grievous injuries on his person and later on succumbed to his injuries. It is further submitted by learned counsel for the petitioner that thereafter an investigation started, and after completion of the investigation, charge sheet was laid against how many persons?
Charge sheet was laid against 11 persons.
11.
Against 11 accused persons, including the present petitioner. However, the present petitioner, along with 2 other persons, namely Anwar Hussain and Asraful Hussain, were shown as absconder in the charge sheet. It is further submitted by learned counsel for the petitioner that after laying of the charge sheet, the committal court, that is the Court of Learned Additional Chief Judicial Magistrate Borpeta, by order dated 17/8/2023, had issued summons to the accused persons named in the charge sheet, including the present petitioner. Stop. It is submitted by learned counsel for the petitioner that though the learned committal court has issued summons to the present petitioner, however, as one of the offense under which the charge sheet has been laid is one of the offense
Yeah, 326, 304, 302 is there.
302. As section 302 is also one of the offense under which charge sheet has been laid, and as the punishment for the said offense, as the maximum punishment for the said offense is death penalty, the committal court, being the court of judicial magistrate first class, may not.
Additional CGM.
It is a additional
CGM forfeit.
committal court, that is the court of additional chief judicial magistrate, may not grant bail to the present petitioner even if he appears before the said court in pursuant to the summon received by him, because of the embargo as provided under section 437 clause 1 subclause Roman 1. Where is the embargo that magistrate cannot?
That is lordship.
Yeah.
437
437
437 within bracket 1 within bracket
One.
small Roman 1, well as section 209 within bracket small a of the CRPC.
1 colon.
1.
437 CRPC stop. And if he is not allowed to go on bail, then as per section 209 within bracket A of the CRPC, the petitioner would be remanded to custody. Hence he apprehend that hence his apprehension is of being detained even if he appears in pursuant to this summons issued to him is genuine. Stop. What is your submission? He let him, on the other hand, learned
Interim.
not interim.
Oh,
Charge sheet.
Charge sheet
oh,
case,
it is
we are
charge sheet
discussing
case. Watch it.
with a direction.
Watch it. With a direction to appear and all.
And when is the next date fixed?
Date lordship already, lordship, it's within 10 days lordship will appear.
No, you have to appear before.
Well, I'll provide after some time, lordship, the date. After some time.
Now, whether warrant has been issued or
No, no,
it's
lordship,
still
that is-
some.
Lordship, I'll later, few minutes later, lordship, just confirm.
Oh, no. No later on. Learned additional public prosecutor submits that though the case has been charge sheeted against the present petitioner, however, from the materials available on record, it appears that the allegation of assault on the deceased by sharp weapon is against another co-accused, namely what is the name?
Hanif Ali.
Hanif Ali.
Yes,
And
Bilal Hussain, others are there.
And as far as common object, that needs to be seen during trial and all. So
and the allegations of involvement of the present petitioner
as to whether he
as
shared
to
the
whether he shared the common object and whether the offense under section 149 IPC is
Is
made out
attractive.
against him would be required to be looked into during the trial.
Mm.
And his apprehension and the apprehension shown by the present petitioner that as the case involved as the offense involved in this case also
302.
one of the offense involved in this case is under section 302, for which maximum punishment is
Death.
death penalty. Due to embargo of section 437 clause 1 within bracket Roman 1, the magistrate court may not grant bail to the petitioner even if he appears in pursuant to the summons issued by the said court. In view of the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, the apprehension of being detained even if the petitioner appears in pursuant to the summons issued by learned committal court appears to be genuine. Hence, it is hereby directed that the petitioner shall appear before the learned committal court, that is the court of learned additional chief judicial magistrate Borpeta, on dash, you give the next date.
Yes.
On dash. And if he does so, if he appears before the said court on the said date, learned additional chief judicial magistrate shall allow him to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the said court. And at the time of, with following conditions. Number 1, the petitioner shall appear before the learned committal court / trial court as and when so required by the said courts. Number 2, the committal court / trial court may impose any additional condition of bail if such court deems it fit to do so. With above observation, this bail application is hereby disposed of.
Highly obliged.
Obliged.
Highly obliged.
May I please, Lordship? Lordship, may kindly see FIR, page 7, madam. Here, my lord, Lordship would say occurrence was on 3/1/23. That is page 23. And after 3 months, she filed FIR. FIR of occurrence held on 3/1/23. but she filed the case on 5/4/23, that is 3 months later. And that too, as per advice of village people. She is my lord 30 years of age, having 4 children. There is consenting party each other. And that's why my lord, since last 3 months she did not file case, totally consenting party. Her husband resides in Gujarat. The case is filed after 3 months. So much delay.
You go through the affair.
Lordship,
I'm taking 1 minute break.
Lordship, yes.
Ah.
And wanted to take her towards the jungle. She refused. Thereafter, he showed some bamboo shampoo, and then, out of fear, she went against her will. It's written against my will. He raped me against my will. And then she didn't tell it to her family members. Later on, once he came to her house also, seeing her father, mother, he went away. So, in a way, consenting party is, I don't know.
Consent may not be there. Consent
Against
may not be there, but delay is there.
delay is there.
So
Because there was a meeting and all in between. They wanted to settle the meeting. And then but the last line of page number 8, but SD accused person did not sit in the said meeting, so the people of the society told me to file a case, and that is why I filed this case. This is, I've come to file this case. Had she been not told, she would not have filed. That is there. And kindly register my FIR. And then 2 days after the incident, accused person gave one medicine and she took it out of fear.
Here means her husband resided in Gujarat. So if she otherwise becomes so
your submission is that it is consensual.
consenting party and
Two submissions may be there.
wrong relationship between that.
One submission is that actually nothing has happened. Other
No.
submission is that they were
Happened.
having an affair.
Yes.
And
Something has happened, and it was
it was consensual relationship.
consensus relationship. And my lord, that is why 3 months there was nothing. Lastly, village people told that you file a case. Then I filed case. And even I offered her medicine and she also took it. Took this because she may become pregnant. That is why her husband is in Gujarat. So that is the out of fear. Fear not for me. Fear of that.
Fear of getting pregnant.
Yes. So this is
Third,
my lord.
Mr. M.U. Mahmood, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional contact person. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Osar Ali, alias Usar Ali, alias Usai Ali, who is apprehending his arrest in connection with Bogoribari PS case number 37/2023 under section 376/506 of the Indian Penal Code. The accusation against the present petitioner is that on on 6/4/2023, the victim slash informant lodged an FIR before the officer in charge of Bogoribari police station, inter alia, alleging that on 3/4/3/1/2023, the present petitioner committed forcible sexual intercourse with her. And at that time, her husband had gone to Gujarat. And after after he came back, the informant reported the matter to her husband. And thereafter, the matter was taken to a village meeting. However, as the petitioner did not attended the said meeting, the informant was advised by the villagers to file a case, and accordingly, the petitioner has lost the informant has lost the case against the present petitioner. Learned counsel for the petitioner has submitted that in the instant case, the allegations of forcible sexual intercourse leveled against the present petitioner in the FIR is not true. In fact, it is submitted by learned counsel for the petitioner that in fact the petitioner and the informant were having an affair, as the husband of the informant resides away in Gujarat. It is further submitted that, and therefore the FIR was lodged belatedly after delay of about
More
three-
than 3 months.
more than 3 months. It is further submitted by learned counsel for the petitioner that the petitioner offered
Me-
medicine to the
Inform-
informant, which she took out of fear of getting pregnant. Stop. Learned counsel for the petitioner has further submitted that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be required. Hence, call for the case diary. Fixing.
If your lordship allowing interim, then January 5th,
Let it be for last week of the December.
and lordship, 7th of December?
27th is the
Oh, it's 20th of December?
20 December. Fixing 20 December. However, in the meanwhile, as it is apparent that the FIR has been lodged delayedly after a period of more than 3 months, and the a village meeting was also held in this regard, as well as considering the submissions made by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation, the petitioner is hereby directed to appear before the investigating officer of Bogoribari PS case number 37/2023 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time in the event of his arrest, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following 2 conditions. Number 1, he shall not directly or indirectly influence the witnesses, right, in detail. And number 2, he shall cooperate with the investigating officer. Let this matter be listed again on
20th of
20th
December.
December.
Matter one there. Along the series, medical report may be altered because
Medical?
she is habituated. So that would prove.
No, she is married, like she has children, so what medical report will suffice?
CD would
CD will.
All right.
Lordship, I beg indulgence regarding item 11, Lordship, as asked me to the next date, Lordship, it is 4/12, Lordship, next date.
item number,
Item number 11, Lordship.
412,
item number
the
11,
dash part.
412.
Obliged.
এই মানুহটোৰ নাম পোৱা নাই ৰঞ্জন কুমাৰ। ৰঞ্জন কুমাৰ নাম নহয় বেলেগ বুজিয়ে পোৱা নাই।
So this singular matter had come up yesterday before your lordship regarding that Mahabhairav Bank.
Regarding,
Mahabhairav Bank, my lord, the
yes,
present CEO had my lord,
the former CEO,
plus former CEO. My
who
lord,
is
the-
he now?
Now, my lord, he is the same person, my lord. The another
again-
affair has been lost, this time by the, my lord, Bar Association of Tejpur.
Oh,
Lordship. And
then I have to look it very carefully.
yes, yes.
Yes.
My lord, but then it would appear, my lord, that somewhere, some, my lord, conspiracy there in lodging of the affair, my lord, that I'll come, my lord. Lordship has seen the, yesterday that affair, that is at page, my lord, 17, my lord.
Why Bar Association has filed?
Because,
How Bar Association
because
got?
they are maintaining 3 accounts in that particular, bank. And they have taken note of the, my lord, the amount as on, my lord, 30/10/2023. Now
This
they
is a separate case.
separate case relating to the same incident.
How it can be?
Because Lordship, the earlier, my lord, your Lordship has found that the RBI has made a report. And on the that accounting, my lord, accounts were made, and thereafter my lord, this has been flown, my lord. And the specific allegation was against the, my lord, accountant of the bank, my lord, Deepjyoti Neo. My lord, you'll find, my lord, that FIR,
ভৈৰৱ
my lord, first, my lord, yesterday's FIR, my lord.
No, yesterday,
Yeah, but-
come to today's case.
Yes, my lord. Yes, today's,
Today's FIR is at page,
yes, my lord, today's FIR is at page, my lord, 25. Today's FIR is at page 25. It is lodged by the Secretary of the Tezpur Bar Association. May I read, ma'am?
yes,
It is hereby to inform you that the Tezpur Bar Association, Tezpur, an old customer of the Mahabhairav Cooperative Urban Bank Limited, Tezpur, since long, and having so, there are 3 accounts number of our state institution, like Tezpur Association saving account number showing so, rupees 1,19,971 only as on date 39/23. Well, this as on 39/23, they have this amount. Then second account, Tezpur Bar Association rent saving account number so and so, 12,05,000 so and so only as on date 39/2023. The third, Tezpur Bar Association e-library saving account number so and so, rupees 7,80,000 407 as on 30/10/2023, and in his this way the total amount in the said account are to the tune of rupees 20,43,781. This is as on 39/2023.
yes.
My lord, I have resigned from the post. If your lordship will recollect the earlier day, my lord, I have resigned from the post on 14/7/2020, 3 years back. That was
You have given your resignation in this,
yes, my lord. We
Where?
find at page 12, my lord.
yes, on 16/7/2020.
Yes, my
your
lord, the board of
resignation.
directors have accepted it on, my lord, 14/7/2020. And I have, my lord, handed over charge. This is the, my lord, charge report, my lord, followed by the charge report. So from that day, also, I don't have any connection. And as on 39/2023, this association has this amount in the end. In their respective account, this amount they have. And in this subsequent paragraph, your lordship will find now they apprehend that something has gone wrong in the bank, so therefore they will be deprived of the amount. Now, my lord, if your lordship proceeds thereafter, my lord, rupees 20,43,781 only deposited in the bank at present. Besides this,
No. Why, what is the FIR of the Tejpur Bar Association? They had this much of amount. Thereafter, what is the allegation?
my lord, thereafter they say, from a reliable source, they have come to know that some of the officials and also, my lord, this ex-CEO, that is present petitioner, collection agent, etc., dishonestly misappropriated an embezzled crores of money from the said bank, resulting huge loss to the said bank and public at large. Due to the said fraud committed on the part of the said bank employees, the Reserve Bank of India by directive so and so dated 12/10/2023 took action under section 35A read with section 56 of the bank regulation Act 1949, that it is abundantly clear after going through the above said notification that the said bank employee, including daily collection agent, ex-employee CEO Ranjan Sharma, most illegally, dishonestly, and fraudulently with their criminal intent in order to obtain wrongful gain for them, had cheated us and other customers and criminally conspired to siphon off huge crores of money and have committed thereby criminal breach of trust and have willfully misappropriated said money of the institution and criminally conspired to make illegal gain among them. The employee of the said bank who had misappropriated.
No, read para number 2 again.
Two again. Yes.
That we have gathered some specific information.
Yes, ma'am. That we have gathered some specific information from reliable source, the daily collection agents as well as bank staff, including the ex-bank CEO, namely Ranjan Sharma of the state bank, that is petitioner, have dishonestly misappropriated and embezzled crores of amount from the state bank, resulting huge loss to the state bank and public at large. Due to the said fraud committed on the part of the said bank employee, the Reserve Bank of India had directive numbers so and so took action under section 35 read with section 56 of the Banking Regulation Act. Both this section, so far as 35A is concerned, it is the power of the Reserve Bank of India to issue certain direction to the management of the bank. And so far as 56 is concerned, it says that the banking regulation is applicable to the cooperative bank as well. So certain directive might have been issued to the bank. So on that basis, they have seized. But a very important, notable thing is that gathered some specific information from reliable source. That what the earlier FIR Lordship has seen, it was given by the CEO of the present CEO of the bank, specific allegation against one Deepjyoti Nath that about 30 crores and odd rupees he has siphoned to his private accounts. In different accounts, those are also seized. Now, so far as this FIR is concerned, they, while narrating these incidents, now the last part, if your Lordship goes to see, your Lordship will find they apprehended their amount will be, they will lose their amount. Whereas 39/2023, the amount is in the bank, they have no dispute on that matter. They are satisfied with that. Now they apprehend that because of that incident, they may lose. Whereas I have retired, so far as 2020 itself, my involvement in this case, absolutely oblique. It is only to implicate me, this somewhere some conspiracy there's by putting this source specific gathered from a specific knowledge. The bar association could have mentioned that from this source we have got. In the earlier application, Lordship has granted me bail because there's no allegation against me, and rather
The earlier FIR is, you have annexed the FIR.
Yes, yes.
Where is that FIR?
Yes, that is at page 17.
Where the specific allegations were against one Deepjyoti Nath.
Yes, page 17.
This was the FIR by the present CEO.
Present CEO.
So he may be in a better position to know.
Lordship will kindly see, yes, I beg to inform you that from the data obtained from the investigation carried out by the auditor of the
You
Reserve
have
Bank of
the order, bail order with you.
Yes, sir.
Yes,
Officer Deepjyoti Nath, son of
Okay,
Ajit Kumar Nath.
we are calling for the case diary on the fixed
Yes.
same date.
Lordship, yes.
Same date. In the
Because-
meanwhile, let him appear, because though this is a
Well, this is
FIR
the
by the bar,
Second
No,
FIR,
this is
that
an
is another
application
thing,
by the
bar, but
apprehending certain things.
the bank manager himself had lodged an FIR
Mm.
making specific allegations against some other
yes,
person, and no allegations were leveled against this.
against this.
Okay.
Slowly, the entire things will be unearthed.
Second part, it's a second FIR, that Lordship, Amit Bhai case, that for the specific Supreme Court says that this second.
No, here the
No, whether a
accused
separate,
are different.
whether separate case has been registered.
Yes, my lord, this is second FIR, my lord.
For the same incident?
The earlier one, my lord, Lordship has considered yesterday for the purpose of bail, my lord. That is Tezpur PS case number 815, my lord.
But this case is different.
This is a
Accused are different.
Accused of the
Same bank, same transaction, my
same
lord, same things.
graver
bank,
offense.
there may be many transactions.
Only
Not
thing that they apprehend, that's not. Anyway, that, my lord, I'll be happy, coming for the question, etc., my lord. For that. That is for the increase, my lord, I may kindly be.
Heard Mr. P. J. Soikia, learned senior counsel assisted by Mr. M. Alam, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by Shri Ranjan Kumar Sharma, who is apprehending his arrest in connection with Tejpur Police Station case number 894/2020 406/409/420 of the Indian Penal Code. The gist of accusation against the present petitioner in this case is that on Three 11/2023, the General Secretary of Tejpur Bar one Biraj Nath, General Secretary of Tejpur Bar Association, lodged an FIR before the officer in charge of Tejpur Sadar Police Station, inter alia, alleging that the Tejpur Bar has three different accounts in the Mahabhairav Cooperative Urban Banks Limited, Tejpur, wherein the total amount of deposited money of the Bar Association is rupees 20,43,781. And it is alleged in the FIR that the first informant gathered some specific information from reliable sources that the daily collection agents, of the bank, as well as bank staff, including the ex-bank chief executive officer, namely the present petitioner, dishonestly misappropriated and embezzled crores of amount of the said bank, resulting huge loss to the said bank. And as a result of which, the Reserve Bank of India has issued certain directions under Section 35A and Section 56 of the Banking Regulation Act 1919. Stop. It is also alleged in the FIR by the first informant that seven numbers of persons, including the present petitioners and some other office bearer of the governing bodies, are suspected to have entered into criminal conspiracy in misappropriating huge amount of money from the said bank. Stop. Learned counsel for the petitioner, on the other hand, submitted that learned senior counsel for the petitioner has submitted that the present petitioner was the chief executive officer of Mahabhairav Bank, Mahabhairav Cooperative Urban Bank Limited at Tejpur, and he tendered his resignation from this said post 3 years ago. That is on when you tendered your resignation.
But it was accepted on 14/7/2020.
In the month of July 2020, which was accepted by the Board of Directors in its meeting held on
14
14 July
July
2017,
20.
2020. It is further submitted by learned senior counsel for the petitioner that there is an allegation of misappropriation of money of the Mahabhairav Cooperative Urban Bank Limited. However, the allegation is against, no, however, in that respect, the present CEO of the bank, namely Shri Praveen Chandra Lakar, has filed an FIR before the Superintendent of Police Tejpur on 4/10/2023, specifically naming therein that that an amount of rupees 34 lakh has been misappropriated from the bank, from the coffers of the bank by the accountant of the said bank, namely Ajit Kumar
He is
Nath,
bank auditor come IT.
namely
Deputy
Deep Jyoti Nath, who is the
bank auditor come IT.
bank auditor
Come IT.
cum IT officer. Stop. It is further submitted by learned senior counsel for the petitioner that in the FIR lodged by the General Secretary of the in the present FIR lodged by the General Secretary of the Tejpur Bar Association, the source of information against the present petitioner has not been disclosed in the FIR. Moreover, plain reading of the FIR would reveal that only a suspicion has been made against the present petitioner by the said informant, and no specific amount has been stated therein, whereas in the FIR lodged by the present CEO of the bank, a specific amount has been stated to be embezzled by the present employee of the bank, and specific allegation has been made against one Deep Jyoti Nath. Deep Jyoti Nath. Stop. Learned counsel for the petitioner, senior counsel for the petitioner has also submitted that this court had already granted interim bail to the present petitioner in connection with the case, in connection with the similar case which was registered on the basis of the FIR lodged by the present CEO of the said bank. It is further submitted by learned counsel for the petitioner that the petitioner, having been retired, having been resigned from his post long back, 3 years, that is long back in the year 2020, is no way involved in the offense alleged against him in the FIR filed by the first informant, and it is further submitted that he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that considering the nature of allegations leveled against the petitioner, perusal of the case diary would be necessary, hence call for the case diary.
28th, same date.
No, when this case is fixed, earlier case,
2012.
Same date.
let the case diary be called for on 20/12/2023. However, in the meanwhile, considering the fact that the petitioner had already resigned from the said bank way back in the year 2020, and he is ready to cooperate in the investigation and has already been granted interim bail in a connected matter by this court in AB case number 3940/2023, the petitioner, namely Shri Ranjan Kumar Sharma, is hereby directed to appear before the investigating officer of Tejpur PS case number 849/2023 within a period of 10 days from the date of this order, and shall cooperate with the investigating officer in fair completion of the investigation. And if he does so within the stipulated period of time, in the event of his arrest in connection with Tejpur PS case number 894/2023, the above named petitioner shall be allowed to go bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2, he shall not directly or indirectly. And number 2, he shall cooperate in the investigation. Let this matter be listed again on 2012 for case that. Yes. Appointed.
I'm obliged if your lordship is taking it. Lordship has already seen yesterday and the girl's statement.
Sure. Record.
PW3 was the victim here. Where she had stated that she went to her sister's residence, and then her sister's brother-in-law had initially, what she stated in her statement is that initially he was harassing her.
LCR.
Lordship can see PW3 statement. Because in such cases, only her statement, if it inspires confidence, Lordship can believe, or else Lordship can allow him to go on bail. This is 389 only.
Yes.
PW3, Lordship will see what she had stated. There. Her examination in chief is that informant is my father. I know the accused person. I'm about 19 years. I studied in so-and-so. At the time of incident, I was studying in class 9. The incident took place in 2020. I was then 17 years. At that time, I went to matrimonial home of my elder sister Manwara Khatun, situated at so-and-so, and stayed there for around 7 days. My brother-in-law Amir Hamza was at Guwahati at that time. That is sister's husband. During my stay at the house of my sister, the accused, who is the younger brother of brother-in-law, used to harass me by offering his love proposal to me. I refused to accept his proposal. One day at around 9:30, I went to ease myself outside the house, and at that time, Ainal gagged my mouth and dragged me inside his room. I told him, but he did not release me. I will tell my sister about the same, to which the accused replied by telling me that if I dare to disclose the same to anybody, I would be killed. The accused then forcibly committed rape upon me. I then cried. On the next morning, I narrated the incident to Ainal's mother. But Ainal's mother, instead asked me not to worry, stating that they will accept me as their daughter-in-law in due course of time. I then came back to my parents' house. 2-3 months later, I came to know that I have become pregnant. In the meantime, I came to know that the mother of the accused had sent her son to Kerala. I did not disclose the pregnancy to my parents and instead talked to Ainal over phone, asking him to come back and marry me. The accused then assured me and asked me as to go to his mother's house. In the meantime, my father and my brother-in-law came to know about my pregnancy. During my 6 months pregnancy, my father and my brother-in-law took me to the house of the accused and sought justice for me. My father and my brother-in-law had then left me in the house of the accused after the family members assured to provide justice to me. After a few days, mother and some other relatives administered some pills to me. I lost my senses after having the said pills. I was then taken to the hospital and my pregnancy was aborted, and thereafter they sent me to my parents' home. I told my parents about the abortion and also told them that once Ainal returns from Kerala, the family members of Ainal will solemnize our marriage. However, the accused did not return. My father then went to Ainal's home and sought a bisar. But as no bichar was held, the matter was placed before the society. But as my father did not get any response from them, however, later the family members of the accused solemnized the marriage of the accused with one Romela. On the next day of marriage, my father lodged the ejahar. And cross-examination, it is not demolished, her statement. Lordship can go to her 164 statement straight away. I'll just take your Lordship to her 164. What is that? I don't know. Lordship can record that 164 statement once. If it tallies, then Lordship can, it's in Assamese, not translated, no?
And even just one thing I'm pointing out in the deposition lordship, she said that the offense was committed in the year 2000. Just one thing, your lordship will see.
I'll go to her. We will break the statements after reading
In
164.
deposition, she said the incident took place in the year 2000. In her deposition, and that's what she stated in her 164 that your lordship will.
She said that it happened in 2020 when she was 17 years old. In her 164, Lordship will see Mur Baido, Vindo, Gorot, Nothokar, English, I know. নথকাৰ বাবে মোক তেওঁ ঘৰলে মাতি পঠিয়াই বাইদেৱে ঘৰ গোগবন্ধা গাঁৱত হয় মই ইমান তাৰিখে তালৈ যাওঁ কিন্তু ইমান তাৰিখে ভিন্দো ভাই কিন্তু আচ্ছা she went on 2/2/2021 and তাৰিখে মই যাওঁ কিন্তু 17 to 2021 and 18 to 2021 তাৰিখে ভিন্দোৰ আইনাল হকৰ ঘৰত ভাইটি আইনাল হকৰ ঘৰত কোনো নথকাৰ সুযোগ লৈ মোৰ চুলা and all those মোক হেৰি কৰি তাৰ ৰুমত নি ৰেপ কৰে এই ঘটনাৰ বিষয়ে মই কাৰোবাক ক'লে মোক মাৰি দিব বুলি ধমকি দিয়ে মাৰি পেলাব বুলি মই এই বিষয়ে আইনালৰ বাইদেউ আৰু মাকক জনাও কিন্তু সিহঁতে তাক কেৰালাত পঠুৱাই দিয়ে মই ঘৰলৈ ঘূৰি আহোঁ 2-3 monthsৰ পাছত মই প্ৰেগনেন্ট হওঁ তেতিয়া মোৰ দেউতাই আইনালক ফোন কৰে তেতিয়া আইনালে ঘটনা
Item 18. Lordship kindly pass the order. Item 19.
At two, my lord. RJ Buru has already got.
At two. That sheet submitted. Go to the trial court. Heard Mr. M.I. Hussain and the counsel for the petitioner. Also heard Mr. R.J. Burwal and the petitioner who submit that in the meanwhile, charge sheet has already been paid. In view of laying of the charge sheet, this bail application, charge sheet has already been laid by bearing charge sheet number
169/2023, dated 31/10/2023.
In view of laying of the charge sheet, this bail application is hereby disposed of with an observation that the petitioner may approach learned trial court and may pray for regular bail before learned trial court. Keep silent.
Okay. Sorry, my lord, signature will be taken after from the my signature will be paid. Obliged.
20 also, we have not received the case diary. And I'm sorry, Lord, we have received the case diary. 20.
Counsel is not
20.
call it after some.
My lord.
May I please, your lordship? 439 application, lordship. Lordship,
Yes,
lordship, allegation is under section 304B of IPC, lordship.
since
Lordship,
how many days you are behind the bars?
71 days, lordship.
Since when?
Arrested on 14/9/2023. FIR is on page 11, lordship. Page 12, lordship.
How he died?
The postmortem report reveals lordship he died of antemortem by hanging lordship. The only lordship the minor Nijara and all this chemical examination report that is pending. And the minor witnesses are recorded in this case, lordship, most of them they are family members of the victim girl. Lordship. They said that the accused person he used to demand money, lordship. That is there. But other independent witnesses they have said nothing.
Heard Mr. D. Mehdi, learned counsel for the petitioner. Also heard Mr. R.J. Borwal, learned petitioner for the prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Nilim Akash Medhi, who has been detained behind the bar since 14/9/2023, within bracket, since last 71 days, in connection with Paltan Bazar PS case number 405/2023. The gist of accusation against the present petitioner is that on 13/9/2023, one Srimati Snehalata Dwara lodged an FIR before the officer in charge of Paltan Bazar Police Station, inter alia, alleging that the daughter of the first informant was married to the present petitioner, and after the said marriage, she was subjected to torture and on 11/9/2023, the informant came to, and on 12/9/2023, the informant came to know that her daughter died on 11/9/2023 at about 8 p.m. Stop. Learned counsel for the petitioner submits that. Is there any submission?
Lordship, the period of considering the period of detention.
That the petitioner has been detained behind the bar since last 71 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Paltan Bazar PS case number 405/2023, and has submitted that from the post-mortem examination report available in the case diary, cause of the death is found to be as a result of ante-mortem hanging. However, the viscera of the deceased has been sent for chemical examination to the FS forensic laboratory. It is further submitted that those witnesses who are the family member of the deceased have implicated the present petitioner. However, the independent witnesses whose statements were recorded under section 161 CRPC have not stated anything about or about subjecting the victim
Demand
deceased
of dowry.
to torture by the present petitioner and the demand of dowry to her as alleged in the FIR. Stop. Considering the progress made in the investigation, as well as considering the fact that considering the period of detention already undergone by the present petitioner, that is 71 days, further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of the Paltan Bazar PS case number 405/2023. Hence, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro, with a condition that he shall cooperate in the investigation. With above observation, this bail application is disposed of. Send back the case.
That is your. May I speak for updated case diary, Lord?
Look, we have received the case that this is up to date, Lord. But by the statement of the witnesses, statement of the accused persons were not in the case diary after inquiry, whether they appeared or not.
They have appeared, Lordship. Lordship, the order of interim
Statement
protection.
not there. Any other endorsement that they have appeared or not?
That is also not there, also whether they have appeared or not.
Lordship, the interim order was passed on 12/6/2023. And on 19/6/2023, the petitioners appeared before the PS, but they were told that the investigating officer is busy and he is not present in the PO. Thereafter, also the petitioners, they kept approaching the PS. And finally, on 23rd June 2023, the statement of the petitioners were taken.
Recorded.
Were taken, but it is not 23rd of. And one local council from Mongoldebar also accompanied the petitioner to the PA.
What is the allegation? What has been alleged against you? 302.
Lordship, the allegation, Lordship, is that the uncle of the so-called uncle of the deceased, he has lost an affair, and that uncle he hails from Gwalpara. He has alleged that on the morning of 21st June, he got the information from the petitioner number 2 that his nephew, niece, she has died.
How to ascertain whether he has appeared? You can seek telephonic instruction. Let him seek telephonic instruction whether heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. R. J. Purwa, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioners were granted interim anticipatory bail by order dated 12/6/2023, and in pursuant to direction of this court, they appeared before they went to meet the investigating officer on several occasions. However, on earlier occasions they could not meet him. However, but on 23/6/2024, they again went to the Sipajhar police station along with a local council to meet the investigating officer, and on that day their statements were recorded by the investigating officer. On the other hand, learned additional public prosecutor who has produced the case diary of Sipajhar PS case number 183/23 has submitted that from record the statements of the present petitioners were not found found in the case diary. Hence, he seeks some time for taking telephonic instructions from the investigating officer as to ascertain the fact as to whether the petitioners have appeared before the investigating officer in pursuant to the directions of this court. The prayer is allowed. Let this case be listed again on 28/11. And the learned additional public prosecutors shall seek necessary instructions from the investigating officer in the meanwhile. The interim order shall continue till next day.
Maybe. This is I'm not pretty sure Milan is a 438 application. There is a cross case also Milan. I am Milan. One CDO's call for Milan on 26/23 Milan. Interim was granted for them. And by
Case diary not received.
by the interim order, we appeared before the IO and our estimate has been
Heard
recorded.
Mr. A. Rashid, learned counsel for the petitioners. Also heard Mr. R. J. Barua, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on
6/12.
6/12. The interim order shall continue till next.
May please your lordship. My lord, here in this case, the accused petitioners were given interim bail by order dated 26/6/2023. My lord, after getting this interim order, they have appeared before the police station on 2/7/2023.
When the interim bail was given?
My lord, on 26/6/2023.
26.
26/6/2023, and they have appeared on 2/7, my lord. And on that day, my lord, IO was not available in the police station. He was on leave. And IO, our telephonic instruction, directed the petitioner to appear before the one constable, my lord, namely Osim Kumar Deuri. And copy was handed over him, handed over to him, and he has also, my lord, acknowledged the receipt of this, and that copy, my lord, I have furnished before lordship. That is also in record, my lord. And subsequently, my lord, on several other occasions, my lord, on 19/10/2023 also appeared before the IO. IO, my lord, did not record their statement saying that CD is sent to the High Court, cannot. Then, my lord, I think, my lord, CD is returned back. After return, my lord, they have again on 2-3 occasions appeared before the IO for recording their statement. Their documents were taken, my lord.
My lord, we have received the case diary, lordship. My lord, pursuant to the direction by this honorable court, we have sought instruction whether they have appeared or not. Now, lordship, IO has filed his objection, lordship, that they have not appeared. And today morning also we have taken lordship telephonic instruction that whether these two persons have appeared or not. The investigating officer has informed us that they have not appeared. Well, this is the report of the investigation.
My lord, absolutely, my lord. My lord,
Instruction lordship, they should appear before the IO within 7 days.
The IO is not acting properly, my lord. We have appeared on several occasions. That, my lord, the order I have, lordship, I have already furnished. Lordship, may kindly have a look at this copy. This copy, my lord, they have appeared before the IO. IO did not. IO was abstaining and directed to appear before the one constable, and that has been. The copy has been furnished and that has been, my lord, given acknowledgement. And the IO is now, my lord, subsequently on several occasions, my lord, on 19/10, on 17/11, on 20/11, we have appeared before the IO. IO is avoiding and did not record our statement, my lord. Now the IO is giving, my lord, wrong information. It's absolutely misleading information, my lord. IO, my lord, the political, my lord, influence with they are trying to harass us, my lord.
To bring your submissions on record by way of an affidavit.
My lord, my lord.
Because
my lord,
apart from your oral submission,
my lord,
when have you appeared?
Yes, my lord.
And to show.
Yes, my lord. I will file an affidavit
My lord, if lordship, my lord, permits me giving a fresh direction to appear, we will again appear, my lord. We will again appear. We have appeared on several occasions.
For that, Lordship, we have to send back the case diary, Lordship.
What do you suggest?
Well, their statement is necessary in this case because there are some allegations against them, what I found from the case diary, Lordship.
No, they are stating that.
Well, that is, I'm
Yes,
submitting
now
from
I-
the note, my lord, I'm submitting from the my lord, note of the investigating officer, Lordship. He has given a report that they have not appeared.
No,
No, my
now the
submission, Lordship,
facts are disputed.
yes, I have to now send back the case diary. Lordship may again direct them to appear within 7 days without fail. And I'll send back the case diary tomorrow itself, Lordship.
My lord,
And Lordship
I will
will fix
appear.
that
We will
matter
appear.
after 10 days or my lord.
my lord,
In the meanwhile, you may submit, you
my
may,
lord, we will file.
you may file you may bring any facts on record by filing
My
an
lord.
affidavit.
And we may be allowed to remain on interim bail, my lord.
Heard Mr.
Yes,
A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioners were allowed to go on interim anticipatory bail by order dated 26/6/2023 and thereafter as directed by this court, the petitioners
My lord, we,
went to Heloguri police station to meet the investigating officer. However, they could not meet the investigating officer. And on first date, you could not meet.
I was not available.
I was
The constable
investigating
received the copy.
on the first date. They could not. The investigating officer was not available. And who instructed you to give the
My lord, I over phone, my lord, instructed.
and the investigating officer over telephone instructed whom?
Instructed the accused petitioner to appear before the Oshim Kumar Deori, his constable.
There are many two petitioners
Yes, two petitioners, both the petitioners, my lord.
to whom the IO telephone,
My lord,
because these are verifiable facts.
my lord, Habibur, my lord, accused number 2, who is
Telephone to one of the petitioner and instructed him to submit the photocopy of the anticipatory bail order to the constable Ashim Deori, and accordingly the petitioners furnished the copy of the order to the said constable, namely Ashim Deori, and to this effect an acknowledgement receipt was also given to the petitioners. Learned counsel for the petitioner has further submitted that thereafter also on several occasions the petitioners appeared before the IO. However, the IO they appeared before the investigating officer, right? Appeared before the investigating officer. However, he did not recorded the statement of the he did not record the statement of the present petitioner. On the other hand, learned additional public prosecutor has produced the case diary of Heloguri police station case number 29/2023 along with a bail objection memo filed by the investigating officer of the Heloguri PS case number 29/2023 and has submitted that he has been informed by the investigating officer of the case that the present petitioners have not appeared before him. in view of the rival submissions made by learned counsel for both the sides, the petitioners, namely Budhen Bhagavati and Habibur Rahman, are hereby directed to appear before the investigating officer of Belogori PS case number 29/23 within a period of 10 days from the date of this order. In pursuant to the direction, in continuation, this order is in continuation to the interim anticipatory bail order granted to the present petitioners by order dated 26/6/2023. The additional public prosecutor shall send back the case diary so as to facilitate recording of the statement of the present petitioners by the investigating officer if he so desires. In the meanwhile, let this case be listed again on
The 6th of December.
6th of December. In the meanwhile, the learned counsel for the petitioner is given liberty to bring on record any facts which he desired to bring by filing an affidavit to that effect. Let this case be listed again on 6th of this.
May I pray to my lord, the copy of the order may be furnished to us.
Let the copy of this order be furnished to learned additional public prosecutor.
Mark of the.
Deeply obliged.
Into the lady for the step.
My lord, here, Lordship was pleased to call for my lord, city my lord. We have not received case there, my lord. They are in interim, my lord. I pray for another deadline.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on
8/12, man.
8/12. The interim order shall continue till next day.
City was.
My lord, here is also similar prayer, my lord. He did not receive, my lord. It's from Kamrup Metro, my lord, Dispur, my lord.
I'm on interim lordship.
Heard Miss J. Ghosh, learned counsel. Heard Miss A. Das.
Yes, Lord.
A. Das, learned counsel for the petitioner. Also heard Mr.
My lord.
B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed.
My lord.
Let this case be listed again on
8, my lord.
8/12.
My lord.
The interim order shall continue till next day.
We have here first 10 lordship, Pandakula plus 17 lordship. Official of section 366, 326.
My lord, here we have received the case there, my lord, without medical report. My lord.
What was the allegation?
376. Affair page 10 lordship. And third copy.
376.
376, my lord. Unfortunately, my lord, he is also mentally retarded, my lord.
Especially able.
Especially able part.
So the witnesses' statements may
My lord, witnesses her 164 statement, my lord, second, my lord. With the help of his family members, my lord.
whether she implicates.
Implicates, my lord. Implicates, my lord. He is the main person, my lord, who committed the offense, my lord.
Then this is not a fit case.
My lord.
Heard Mr. A.K. Azad, A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. D. Sharma.
B Sharma.
D. Sharma.
B.
B. Bombay.
My lord, Bombay. All of them B Sharma, my lord. We are here.
B. Sharma, Learned Counsel, Learned Additional Public Prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sadiqul Rahman, who is apprehending his arrest in connection with
Not looking for PS.
North Lakhimpur PS case number 307/23 under section 366/376 of the Indian Penal Code. The accusation against the present petitioner is that one Sukur Ali, on 22/8/2023, had lodged an FIR before the officer in charge of Siloni Bari Police Outpost, inter alia, alleging that the present petitioner on 7/8/2023 had kidnapped the daughter of the first informant and have sexually assaulted and has sexually assaulted her. Stop. Learned counsel for the petitioner submits that the petitioner is innocent and the allegations leveled against the present petitioner in the FIR are not true. On the other hand, Mr. B. Sharma, Learned Additional Public Prosecutor, has produced the case diary of North Lakhimpur PS case number 307/2023, including the statement of the
Victim under 150.
victim girl, who is a disabled person.
Mentally.
Stop. Learned counsel for the Learned Additional Public Prosecutor has vehemently opposed the grant of bail to the present petitioner on the ground that there are sufficient incriminating material against the present petitioner in the case diary. I have heard the rival submissions made by learned counsel for both sides and have gone through the materials available on record, including the case diary of North Lakhimpur PS case number 307/2023. This case involves sexually assaulting a person, a woman, a girl who is mentally
Is not
who is a disabled girl,
well.
and there are sufficient incriminating materials against the present petitioner in the case diary, which does not justify grant of any favorable order under section 438 of the Code of Criminal Procedure to the present petitioner at this stage.
Well.
Hence, the prayer for anticipatory bail is hereby send back the case diary.
Well.
May I please, Lord. My lord, I am on interim in this case. But Lord, allegation under 370, 406, 420.
My lord, here, although my lord, interim, her statement is not available here, my lord.
I appeared.
Whether no, but whether is there any
My lord, materials is there. my lord.
she appeared or not?
My lord, that information is not here, my lord, from the case diary, my lord. But materials are here against the
When you appeared?
If a date, I can't exactly say, Lordship, but our interim order was passed on 26/9/23. After passing of the interim order, I will appear there within 3-4 days. Lordship.
You seek instruction.
My lord, my lord,
Telephonic.
my lord, telephone instruction, my lord.
Heard Mr.
Am I
M.I. Hussain, learned counsel for the petitioner, who submits that the petitioner was granted interim anticipatory bail on 26/9/2023, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer. Also heard Mr. B. Sharma, learned additional public prosecutor, who has produced the case diary of Tarabari PS case number 68/2023 and has submitted that there is nothing in the case diary to indicate that the petitioner has appeared before the investigating officer. In view of the submissions made by learned additional public prosecutor, he is requested to
My lord,
take information, take instructions from the investigating
Well.
officer of the Tarabari case, PS case number 68/23, as to whether the petitioner, namely Maina Devan, had appeared before the investigating officer after she was granted. You are a woman.
Lordship, no.
She was granted interim anticipatory bail by this court on 26/9/2023. The information may be sought telephonically by the learned additional public prosecutor. Let this case be listed again on
Monday, Monday,
Monday.
Monday, 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 Tuesday, Monday.
on 28.
20.
The case diary be retained till
My lord.
next date. The interim order shall continue till next date.
My lord.
Obliged, Lordship. May it please Lordship. Lord, 438 applications, Lord, petitioner before your Lordship with the branch manager of Indian Bank, Lord. Lord, what has happened, my Lord, your Lordship will kindly peruse the FIR, which is at page 12, my Lord. It has been alleged that these four persons have applied for loan and with the help of me, one Obinjit Bora, my Lord, that misappropriate that amount, my Lord.
No,
Really?
whether you appeared before IO.
I appeared, my Lord. Your Lordship will kindly see. I appeared, my Lord. I given all the documents because it's it was on the Prime Minister's Yogurt Yojona's program, my Lord. That has been sponsored by the DIC. DIC, after going verification of their project report, my Lord, they send it to the bank for the purpose of loan, my Lord. And along with, my Lord, the sponsorship letters, my Lord. Then on the basis of it, we give from where they will take the money, take the materials. We, but through RTGS, we give this money to them. Now it is them who has misappropriated or something like this, my Lord. I will show you, Lordship will kindly see. I have appeared, my Lord. I have given my evidence.
Whether there's
My lord, in the CD, my lord, and that part is not available, my lord, whether he has appeared or not, my lord. I will have to take it, whether he appeared or not.
whether your statement
Statement not
he
available.
is submitting
Not available here.
documents are also submitted. Learned counsel is submitting that
My lord.
some documents are also submitted by.
Yes, submitted also, your Lordship. The documents I annexed here also, my Lord, your Lordship will
No,
kindly.
before IO, whether you have.
Yes, my Lord. We have already given that how it has been sent, my Lord, because your Lordship will kindly see that.
No, no.
No, no,
Now,
I'll
now
take exception, my lord.
we will only,
My-
we are concerned with the fact as to whether you appeared before the IO
Yes, my Lord.
within 10 days of the date of the
That
order.
my instruction that they have appeared and they have shown all the bank statement, bank documents to the IO also, how this loan has been sanctioned and how, not to them, to the beneficiaries, my Lord.
You seek instruction.
My lord, my lord.
हमको सोचना था नहीं
No,
ना, नहीं ना, statement.
And if if you think it proper, you may also file an affidavit to that effect, or we may wait for his instruction.
My lord, I will take instruction.
Lordship may take an instruction,
My
my lord, because what my instruction is that,
He has appeared.
Appeared or not?
Heard Mr. P. Bora, learned senior counsel, assisted by Ms. K. Bhattacharya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned senior counsel for the petitioner submits that the petitioner was granted interim anticipatory bail by order dated 5/10/2023. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer within the stipulated period of time. However, learned additional public prosecutor who has placed the case diary of Dergaon PS case number 148/23 before this court has submitted that there is nothing in the case diary to indicate that as to whether the petitioner has appeared before the investigating officer or not. So in view of the aforesaid facts, learned additional public prosecutor is requested to seek instructions over telephone from the investigating officer to, as regards the fact as to whether the petitioner has appeared before the investigating officer in pursuant to the directions of this court by order dated 5/10/2023. Let this case be listed again on
Tuesday, my lord.
on 28/11.
My lord. 28.
Maybe. Okay, here petitioner was granted interim period bail on 9/10/2023. And as per my instruction, he appeared and cooperated.
Whether he has appeared.
My lord, he has appeared, my lord, before the IO statement recorded. But the allegation is, my lord, here. Allegation is serious, my lord, here. 366 kidnapping, my lord. Minor girl, my lord, she is 14 years old.
Whether the girl has been recovered or recovered.
Recovered, my lord. Her statement was also recorded, my lord. In the statement 164, my lord, she has implicated the
Present petition. Now, whether custodial detention would be necessary.
My lord, but although interim he has appeared, my lord, materials are against him, sufficient material.
Okay, no, whether custodial detention would be required.
It is difficult to say. I leave it to lordship, my lord.
No, I would be knowing.
My lord. No,
Is
no,
the IO
my lord, after interim, my lord.
A diary does not indicate anything.
My lord.
That
The
to that
minute-
effect.
my lord.
Heard Mr. A.Z. Azad,
Ahmed.
A.Z. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned
Right.
additional public prosecutor. Learned counsel for the petitioner submits that the petitioner was allowed to go on interim anticipatory bail by order dated 9/10/2023.
Right.
And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the diary of Mankachar PS case number 154/2022 and has submitted that though the petitioner has appeared before the investigating officer and his statement is also recorded under section 161 CRPC. However, learned additional public prosecutor opposed the grant of bail opposed the making of interim bail granted to the petitioner as absolute on the ground that there are incriminating materials against the present petitioner and the victim girl who is a minor has implicated the present petitioner in her statement made under section 164 of the Code of Criminal
The
Procedure.
medical report also some injury.
And the medical report medical report is also against the present petitioner. So I have considered the submissions made by learned counsel for the both sides and have perused the materials on the record, including the case diary of Mankachar PS case number 154/2022, along with the statement of the victim girl under section 164/164 of the Code of Criminal Procedure, 1973. Though there are incriminating material against the present petitioner in the case diary, which is indicated from the statement of the victim girl which was recorded under section 164 of the Code of Criminal Procedure. However, it also appears that the petitioner has complied with the directions of this court and has cooperated in the investigation in the investigation, and there is no material found in the case diary to suggest that the custodial interrogation of the present petitioner would be required at this stage of the investigation for fair completion of the investigation. In view of above, the interim anticipatory bail granted to the petitioner by order dated 9/10/2023 is hereby made absolute with following conditions. Condition number 1, he shall not directly or indirectly make it complete, and he shall cooperate in the investigation. With above observation, this anticipatory bail application is thereby.
Made lost him. All the petitions are interim, my lord. They have already appeared in the recorded, my lord. Matters relating to my lord, to cousin brothers, my lord.
All petitioners are on in.
All are interim, my lord. And they are all the cousin brothers, my lord, relating to my lord land dispute. First case also there. And your lordship will find FIR is page 10.
Have they appeared?
They
Ms.
appeared,
Bora?
my lord, statement recorded.
Lordship, statements recorded, and after calling for the case diary, Lordship would have found the medical report. And medical report, they have inflicted injuries on one unknown operative, and as per the report, the previous injury was sharp of paper.
Okay.
Who did it, my
And Lordship, I have gone through the statements of the witnesses also, and they have indications that were Dr. Muhammad Ali and his sons, and one Saidur Rahman. The names are specifically mentioned.
Madam Muhammad Ali 65 is father, my lord, and others are son. Number 1 is the father, 65 years old. Son number 2, 3, and 6. And 4 is the, my lord, that nephews, 4 and 5.
Those are mob attack by the family members.
Dispute, madam, from the FIR itself, you also find. First case also there. Both the cases, our case also, injury also there. Occurrence is admitted, my lord. Occurrence is admitted. It is, my lord, regarding the inherited land from my grandfather.
What kind of injury? Where?
It's Lordship, as per the medical report.
Both the case diary was called.
Proximal radius with inability of finger extensions, cut injury, and it's finger cut injury in the finger.
You have filed cross FIR.
Yes, title suit is pending. The law pending title page 16, my lord. My cross FIR is my lord, page 21. Page 21. First, you kindly say page 16. Title suit. pending before the party. It is filed on 13/3/23, page 16, your lordship.
When they have appeared,
13/3/23 it is filed, then my lord, your lordship will find next 1/11/20. No, first hearing 13/3/23. First
no,
hearing.
no, at this stage, we are concerned
Yeah.
that once you have appeared, but there are some grave allegation against.
But your lordship kindly see, my lord, that case number page 18. What I am
1810.
saying, madam, admitted land dispute. Occurrence also admitted. And court case title suit is pending for last 1 year now.
They appeared before the IO on 1810.
When 1410,
1810.
18.
1/8.
and is there any endorsement by the IO that
Uh,
their custodial detention may be?
That is not their lordship. It is up to 1810. Thereafter, it is not applicable.
What is your submission?
Admittedly, there is a prior long-standing consultation regarding there's a land dispute.
Because we are only concerned with limited question, whether to make the bail absolute
Yes.
or whether the nature is so heinous that
Yes. Cut
somebody
injury
has
in the finger, lordship, so far as reports.
heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Ms. H. Ahmed, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. Learned senior counsel for the petitioner submits that by order dated 13/10/2023, all the 6 petitioners were allowed to go on interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioners have appeared before the investigating officer and have cooperated in the investigation. On the other hand, Ms. S.H. Bora, learned additional public prosecutor, has produced the case diary of Dalgaon PS case number 409/2022 and has submitted that though the petitioners, after being granted interim anticipatory bail by this court, have appeared before the investigating officer and their statements are also recorded under section 161 of the Code of Criminal Procedure, However, the injuries sustained by one Ainul Haq appears to be grievous in nature, caused by sharp weapon as per the medical report. It is also submitted by the learned counsel for the petitioner that the witnesses have implicated the petitioner number 1 and petitioner number 2, namely Muhammad Ali and Muhammad Saidur Rahman specifically. Both of these 2 petitioners also appeared.
Yes.
Not.
Stop. I have considered the submissions made by learned counsel for the parties and have perused the case diary of Dalgaon PS case number 409/2022. It appears from case diary that though there are incriminating materials against the present petitioners in the case diary, the fact that there is though there are incriminating materials in the case diary, the petitioners have cooperated in the investigation and have complied with the directions of this court. It also appears that that the petitioner's side also filed cross FIR against the other side.
And what is injury or sustained injuries of
And
page 21.
And as submitted by learned senior counsel for the petitioner, there was an altercation between both the parties in connection with a dispute over a plot of land.
Inherited by from the grandmother, both the parties.
Dispute over
Of the land inherited from the common ancestor.
land inherited from the common ancestors of both these parties. Stop. This submission movement, they have cooperated a paragraph is of good. In view of the above, in view of the fact that the petitioners have cooperated in the investigation and this court finds no endorsement in the case diary to suggest that that custodial detention of the present petitioners would be necessary for fair completion of the investigation at this stage. Hence, the interim anticipatory bail granted to the above named petitioners, namely so and so, namely 1, 2, 3, 4, 5, 6, by order dated 13/10/2023 is hereby made absolute with following condition. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of. Send back the case.
33 Lordship, CD was called for that we have not received.
Yeah, Lordship. We are not the FIR name, Lordship.
No, you are on interim bail.
Perhaps petitioners are on interim.
Let us wait. You are opposing.
My name may be recorded.
Okay, let us wait for the case diary. Heard Miss
J. Akhtar.
J.
J. Akhtar.
Heard Miss J. Akhtar, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned additional public prosecutor, as well as Miss R. Begum appearing for the informant. Learned counsel, learned additional public prosecutor submits that though the case diary was called for, however, same has not been received and prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
15/12.
15/12. The interim order shall continue till next date.
Pursuant to the interim order, Lordship, the petitioner appeared, Lordship, to the investigating officer on 2010, Lordship, for 9.
Has he appeared?
Lordship. Yes, Lordship. Statement is recorded.
Yes, Lordship. Pursuant to
Victim has been
Victim is a
recovered.
minor. On my only contention is this victim is a minor, 16 years old girl.
Lordship, although 16 years stated, I have annexed the birth certificate. She was 17 years.
He has been recovered.
She was recovered. She was recovered only under very. She was.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 16/10/2023, the petitioner was granted interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, Ms. S. H. Bora, learned additional public prosecutor, has produced the case diary of Baihatar Tareli PS case number 293/23 and has submitted that the petitioner has appeared before the investigating officer, and his statement under section 161 of the Code of Criminal Procedure, 1973 has also been recorded. She has further submitted that the victim has also been recovered.
Lordship, our 164 statement recorded.
And her 164
That
statement.
submission is given by my Lord fellow. Let's see.
Our 164 statement Okay. She has further submitted that. No, she has recovered, therefore her
Yes,
64
yes.
statement
I have annexed that order also.
and her 164 statement has also been recovered. Considering the fact that the petitioner has complied with the directions of this court and has cooperated with the investigating officer, comma, the interim anticipatory bail granted to the above named petitioner by order dated 16/10/2023 is hereby made absolute.
Okay.
This anticipatory bail application is there accordingly disposed.
Made the direction on the last page to give a joint affidavit, but it is fine. They could bring, they are coming from same guy. The road condition, that's good. So they said that
Since the petitioners are on interim lordship, let them file an application, joint petition lordship at the next day.
Joint affidavit, why?
Yes.
because they are both children of now they are happy with the of the time the FIR was
Okay, okay,
50.
okay. You are seeking some more
Some
time.
more time to file the same.
Heard Miss D. Sinha, learned counsel for the petitioner, also heard Miss S. H. Bora, learned additional public prosecutor. Learned counsel for the petitioner has prayed for allowing the petitioner to petitioner some more time for filing affidavit sworn by the wife of the petitioner as directed by this court by order dated 17/10/2023. Case diary has arrived.
No, no.
Case diary was not called for.
Scan copy of
Okay.
case diary perhaps called for. The matter has been surseated.
Charge sheet and matter. Charge sheet and matter. Warrant of arrest has been issued against you.
Yes, okay.
When can you submit that?
So the route that
Considering the submissions made by learned counsel for the petitioner, the learned counsel for the petitioner submits that the petitioner could not submit the affidavit as directed by this court due to difficulty in transportation, due to difficulty of transport facility. Stop. Considering the submission made by learned counsel for the petitioner, the prayer is allowed. Some more time is granted to the petitioner to furnish the affidavit as directed, as was directed by this court by order dated 17/10/23. Let this case be listed again on, when do you want it? 15th, 12th, 15 December. Let this case be listed again on 15th of December.
Lordship. If we have perhaps
But 438 bail application, Lordship, FIR is case 9, Lordship. Okay, allegation is that the prime accused of the case has made statement that with the help of the petitioner getting the state Erekanapa. Only
Page 9. Yes, what is the allegation?
Lordship, allegation is that the prime accused of the case, Lordship, made a statement before the IO that with the help of the petitioner carrying the state Erekan art.
You are named in the FIR?
Lordship.
Where?
Customary
At page?
page 10, Lordship, can you see? Carrying this item from Uriamgarh to Kharupetia site with the help of the person, namely MD Kasemali, so and so, and
Yes, what is your submission?
Lordship, this is Lordship only because of the police has apprehended to arrest Lordship. Only because of the co-accused of this case made a statement before the IO that we are involved in this matter. And the driver on the handyman was arrested in this case.
How much Areca nut was recovered?
95 bags.
The huge quantity.
Apart from the statement of the co-accused, what else?
My lord, actually from the spot, my lord, both driver and handyman were arrested. So my lord, from their statement, my lord, they have, my lord, categorically said, and my lord, it is a, my lord, illegal trade of, my lord, Areca nut. And my lord, their rule is to, my lord, to escort the vehicle. To escort the vehicle from the, my lord, starting point to the, my lord, the spot.
Now, how the trade of Areca nut becomes illegal? They,
So, my lord,
this
without
is
any
not,
paper.
is it stolen? or
Yes, my lord, that is my lord suspected
Allegation.
because my lord, without any paper, my lord, actually that truck was from the truck, my lord. It is my lord dhania seed, a packet of dhania seed, and my lord, this says some, my lord, till, and in between, my lord, this my lord, Areca nut, my lord, the carried, my lord. And my lord, the Areca nut, they have produced some paper, my lord. They have produced paper, my lord, paper relating to, my lord, this dhania seed, not relating to, my lord, the Areca nut. Areca nut, my lord, without any paper, without any document, they have carried. And my lord,
You know what offense has been alleged? 317.
379 is also there, my lord.
379, 420, 120 people.
468 is also there.
Now I want to understand how Areca nut business becomes.
No, without any paper, my lord. That is the thing. Without any paper. If my lord is huge quantity of Areca nut is, my lord, they have purchased in somewhere, my lord. There are certain bills, my lord.
So I am not the owner of the Areca nut, I am not the owner of the vehicle.
There are certain bills, my lord. Yeah. And that amount, my lord.
No, the query is whether any offense has been committed. There may be some breach of payment of duties,
my lord.
but what offense?
So everything is there, my lord, because without any paper, my lord, GST, Salan, my lord, these are all things should be there, my lord. That is not, nothing is found from their position, my lord.
And therefore it is presumed that it is stolen.
My lord. And my lord, evading the tax of the, my lord, the state, my lord.
Okay. No, but for evading the tax of the state, there has to be specific offense. The offense alleged is 413, habitually dealing with stolen property, receiving stolen property, and 379.
My lord,
Those materials are there.
It is, my lord, in the process of, my lord, investigation is on, my lord. So at this stage, my lord, these
Whether
are, my
their
lord,
custodial detention would be.
my lord, because custody is necessary, my lord, because, my lord, it is an organized crime. This, my lord, 1 or 2 person is not only not involved, my lord. There are certain people, my lord, involved in this. This is a big case, my lord. A court is yet to be apprehended.
Lordship, FIR has been filed by the police, Lordship. There is no 379.
Yeah, police has seized, police has taken a nakaseki. The police will file the FIR.
No, but if you are transporting something, you have to show from where you have carried to whom you are carrying. Some documents have to be there.
Okay, I am not the owner of the vehicle and the owner of the Erekanat.
Then, my lord,
Only because of the prime accused made statement that we are involved in this.
How you came to know that prime accused made this statement?
So the police visited
Okay. Apart from 161, what else is there against them?
my lord, at this stage, my lord,
You
At-
don't have other material.
yes, at this stage, my lord.
So
At this stage.
let them appear.
My lord,
Let them appear before you.
my objection may be recorded, my lord.
Heard Mr.
M. Alam.
M. Alam Lalit. Because there are many cases of areca nuts coming up
Yes, yes.
before this court.
So many cases.
Heard Mr. M. Alam. What is your name? M. Alam.
M. Alam.
M. Alam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed where they have been named. Mr. Sharma, flag it.
My lord.
So it has been filed by the petitioners apprehending their arrest, who are apprehending their arrest in connection with Golaghat PS case number 233/23.
My lord, sorry to interrupt. My lord, samples of this, my lord, Cherikanath sent to my lord, director of my lord, state public health laboratory. Or
No, that I wanted to know whether areca nut is a prohibited object.
yes, my lord, whether it is my lord human consumable or not, my lord, that is my lord for verification of that, my lord, it is sent to that laboratory, my lord. And my lord, so my lord, that report is not coming, not in the case.
Under section 120B/379/411/420/468/284 of the Indian Penal Code. The gist of accusation against the present petitioners. Gist of accusation in this case is that on 21/9/2023, one Jotin Bora of Golaghat Police Station lodged an FIR before the officer in charge of Golaghat Police Station, inter alia, alleging that on receipt of a secret information through reliable source regarding the movement of some illegal goods, in Naka checking was laid at Teteli Tol, Golaghat, and during the Naka checking operation, one vehicle bearing registration number AS01QC 2883. You are the owner?
No, Lord.
You are nowhere related?
No, Lord.
2883 was intercepted, which was coming from Uriam Ghat side. And during search of the said vehicle, it was found that it was loaded with dry coriander and the driver and the handymen of the said vehicle were able to show some documents regarding the said items, namely dry coriander. However, later on during further search of the said vehicle, it was found that several bags of areca nuts were concealed beneath the dry corianders and sesame bags. And for the said areca nuts, the driver and handyman could not produce any documents when same was asked from them. It was found that the total number of areca nut bags which was recovered from the said vehicle was 95. It is further alleged in the FIR that the said areca nuts are suspected to be stolen, and where is your name?
Is 10 row.
And it is being carried with the help of the present petitioners, Qasim and Mohammed. Both are before this court, Junab Ali and Qasim Ali. Who are the petitioners?
Yes, Qasim Ali and Junab.
They carried with the help of present petitioners, namely Qasim Ali and Junab Ali. So, on the other hand, learned counsel for the petitioner submits that the petitioners are in no way involved in the offense alleged in the FIR, and you are not at all connected. That is a submission. They are not connected with the offense alleged in the FIR in any manner, and they have been implicated in this case only because of the statement of the co-accused made against them, which is false. On the other hand, learned additional public prosecutor has produced the case diary of Golaghat PS case number 233/23, which was called for in connection with this case, and has submitted that both the apprehended, there is some arrest also.
There is some arrest also, driver and handyman.
Both the apprehended accused persons who were the driver and handyman of the seized truck have implicated the present petitioner in their statement made under section 161 CRPC. It is further submitted that the seized areca nuts are suspected to be stolen. It is also submitted that the investigation is in its crucial stage and the seized areca nuts have also been sent for chemical examination to where you have sent
It's
it
a directorum, my lord,
for chemical examination.
Yes.
Stop. Learned counsel has, learned additional public prosecutor has opposed the grant of bail to the present petitioners. on the ground that there are implicating materials against the present petitioner. On the other hand, I have considered the submissions made by the conflict for both sides and have perused the materials in the case diary. It appears from the case diary that in the FIR only suspicion is made against the it is only suspected that the seized areca nuts are stolen. It further appears that it is only on the basis of the statement of the co-accused, which were recorded under section 161 of CRPC, that the present petitioners have been implicated in this case. At this stage, apart from the statement of the co-accused, there are no other material against the present petitioners on record. Under such circumstances, if the present petitioner cooperate with the investigating officer in the investigation, their custodial detention does not appear to be necessary for the sake of fair completion of the investigation of Golaghat PS case number 233/23. Hence, the petitioner Muhammad Qasim Ali and Muhammad Junab Ali are hereby directed to appear before the investigating officer of Golaghat PS case number 233/23 within a period of 10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Golaghat PS case number 233/23, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. With following condition. Condition number 1 and
It is, my lord, the Director of State Public Health Laboratory.
sent for chemical examination to Directorate of
State Public Health
State
Laboratory.
Public Health. Send back the case diary. This case is accordingly disposed of.
May I please, your lordship? Lordship, on 10th of November, lordship was pleased to grant interim to me, and the accused person injured a police person. On 16/11, lordship, he appeared before the IO. When he went to the police station, I am extremely sorry to submit before this honorable court, the OC of the police station slapped him thrice in front of my junior. And after that, what happened, lordship? He was seated in front of the police station for 6 or 7 hours. After that, no statement has been recorded. At night, bail was granted. And the name of the bailer is Basir Ali.
The statement is recorded here.
Okay, regarding the other allegations, you have other forums.
Yes, my lord.
He is very much cooperating, lordship. So bail may be approved.
Yes, Mr. Sharma.
Yes, my lord, this statement is recorded. my
Heard
lord.
Mr. B.
G. Samoa.
Heard Mr. G. Samoa, learned counsel for the petitioner. Learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. The learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 10/11/2023.
Yes, Lord.
And in pursuant to the directions of this court, the petitioner appeared before the investigating officer on 16/11/2023.
10.
16/11.
The 12/11, not 12/11, their statement.
Misguided. Yes, yes.
12-11.
12-11.
When you appeared, when you were slapped.
As per my instruction, Lordship, it was 14 in the
You want
morning.
it to be recorded in the order sheet.
That's
That-
not a CD, Lordship.
No, that your
14.
allegation regarding slap,
14.
I'm not on that. I'm on, you have alleged that when you appeared before the IO, you were mishandled.
Yes,
by
Lordship, on 16. On 16.
On 16th.
On 16.
Then your statement were recorded on 12th.
Yes, my lord.
Then thereafter, why you went again?
মার খাবো।
মাৰ খাব মাৰ খাব কোনোবা যাব নেকি আৰু মিছা কথা এইটো
No, I'm not clear. You are not clear on dates. Therefore, I'm not recording it.
Yes,
I was intending to record it and I was intending to issue some direction. But
Yes.
you are not clear on dates on which,
as per my junior instruction, it is 16.
but record shows your statement were recorded on 12th.
Regarding that aspect, I don't clearly my
So-
humble submission is that I don't know regarding.
Unless the facts are clear, it may not be proper to record it.
As per instruction, I am submitting.
Okay.
My lord, actual thing is, my lord, on 16/10, that is the date of occurrence, my lord. That is the date of occurrence. Is it-
On that day,
Yes,
there must maybe some altercation
on that day, my lord, occurrence has taken place, my lord.
Yes,
because
Lord.
you injured some police person.
Yes, my lord, on that day, 16.
On
that
on
day-
16/10,
On 16.
On-
he injured the police person.
Yes,
Therefore, you were slapped.
yes, my lord.
Yes, Lordship.
That is a different issue.
Definitely.
Your submission is not correct.
Yes.
Now we are concerned after granting of interim bail, whether you appeared or not.
Appeared, Lordship, his statement is
You
recorded.
made a statement that even after granting of interim bail, you were mishandled by the police. That is very serious allegation.
Yes.
Therefore, I was putting query. The allegation of altercation with police was prior to grant of interim bail by
Date of
the
incident.
On the date.
Okay. What was the last? Appeared before the investigating officer and his statements and has cooperated in the investigation. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has produced the case diary of Meresar PS case number 75/23 and has submitted that the petitioner has appeared before the investigating officer and his statement was also recorded under section 161 of the Code of Criminal Procedure, 1973. In view of the fact that the petitioner has above
My lord,
the-
petitioner.
the petitioners, plural the both of petitioners, namely Amirul Khanam, alias Amiran Khanam and Amir Khan, have appeared before the investigating officer in pursuant to the directions of this court and have cooperated in the investigation. The interim anticipatory bail granted to them by order dated 10/11/2023 is hereby made absolute with condition number 1 attached to the said order remaining intact. With above observation, this anticipatory bail application thereby disposed of. Send back the case.
Deeply obliged, man.
Made this your lordship 438 by repetition. Under section 376. lordship. FIR is 3 is 9 lordship.
Where is the FIR? At page?
Page 9 lordship.
Yes.
Lordship, petitioner and the informant hailing from the same village, Lordship. The petitioner, I have stated in the para 3, Lordship. The petitioner and the informant developed love and affection towards each other since last 1 year, Lordship. The informant and her parents pressurized the petitioner to get married. However, as the petitioner not in a position to get married at an early date, the instant FIR has been lodged by the informant with an intention to pressurize the petitioner to marry to the informant.
Yes.
My lord, our 164 and my lord medical report is available. My lord, 164 is placed before you.
Yes. There was a love affair.
Yes, my lord. That is,
What is your submission?
well, promises of my lord false marriage is clear, my lord. It's quite evident in our statement. And my lord, that medical report is also there, my lord, prior to death, my lord. And he and that, my lord, that abortion part is also there.
Custodial detention is necessary. Since 21, they are having relationship.
And she is major.
She is the major. Let him appear in open. Mr.
M. Alok.
M. Alok, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by Petitioner Gaurav Kumar Vejpurwa, who is apprehending his arrest in connection Nolbari PS case number 375/23 under section 375/23 under section 376/313/506 of the Indian Penal Code. The gist of accusation against the present petitioner in this case is that on 2/9/2023, the victim girl lodged an FIR before the officer in charge of Komar Kusi police outpost, inter alia, alleging that she was subjected to forceful physical relationship by the present petitioner on the pretext of marriage by the present petitioner. Stop. Learned counsel. It is also alleged in the FIR that as a result of the physical relationship, the informant became pregnant and the petitioner took her to a hospital and compelled her to abort her pregnancy. Learned counsel for the petitioner has submitted that the petitioner is a major and I'll dictate the order in chamber. I'm taking 2 minutes break. Public prosecutor has produced the case diary of the Nalbari PS case number 375/23, which was called for in connection with this case, and has opposed the grant of bail to the present petitioner on the ground that the victim has implicated the present petitioner in her statement made under section 164 of the CRPC, and the medical report of the victim girl also shows that there was a termination of pregnancy. Abortion is there.
My lord, there is there, my lord. In the medical report is also there, my lord. And in the FIR, my lord, and in 164 statement also, allegation is there.
I have considered the submissions made by learned counsel for both the sides and have considered the materials in the case diary, including the statement of the victim as well as the medical report. Though there are incriminating materials against the present petitioner in the case diary, however, it appears that the alleged incident occurred. It appears that the petitioner and victim were in a love relationship, were having love affairs since 2021, and the FIR was lodged only in the month of September 2023. Stop. Considering the fact that both the victim and the petitioner are major and were having love affairs since last 2 years, and considering the nature of allegations leveled against the petitioner in the FIR, his custodial detention at this stage of the investigation does not appear to be necessary if he cooperates in the investigation and refrain from influencing the victim in any manner. And therefore, in view of above, the petitioner, namely, what is the name? Gaurav Kumar Bejbarua, is hereby directed to appear before the investigating officer of the Nalbari PS case number 375/23 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so, in the event of his arrest in connection with Nalbari PS case number 375/23, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of. Send back.
I do oblige, Lordship.
Yes, your lordship. My lord, this is a case, here also, of course, both the case they were called for. Your lordship kindly see the FIR page.
Both the case that.
Yes. Page 14, you kindly see, madam. Page 14 is the FIR where we are sitting bail. Your lordship will find total 10 person named in the FIR.
This is the FIR against you.
Yes, I'm seeking bail. And the FIR filed by us, that is page 20, page 19. In fact, my lord, just a background I'm giving, it will give my lord. Dota petition number 3, your lordship. Present petition number 3, Dota petition number 3 was, my lord, taken by the accused number 1, by the son of that my lord, this informed. Because of the, we filed a case. And that case also is registered under some section of law, my lord. Thereafter, this case also filed, but while the registration of the case matter was something later than the present case matter. Now your lordship will find the background if my lord, just I am taking to your lordship to page 19, my lord, page 19. Just my lord. Then it will make clear, my lord.
What is this? This is
page 19, my lord.
This is also an FIR.
This is FIR filed by us, my lord. Just my lord, for background, it will make it clear that FIR, my lord.
Okay.
This accused number 1, Bodogali. Your lordship will find, my lord. And informant is Dalwagali. Dalwagali is present petition number 3, my lord. So Dalwagali's daughter was that Bodogali. He has married, actually, he was following her while going to the school. She is minor. And this Bodogali is also minor. He is those 16 years age about mine. He was following her and disturbed her. He has taken some videograph. That's why some altercation took place. Right? So this case was filed. Bodogali is the accused number 1. Now the present case was filed. Your lordship, now come to page 14, my lord. In 14, they are saying that we have assaulted Bodogali. That Bodogali. Your lordship got the point, man.
Okay.
Now your lordship will find page 14. With due respect, I beg to state that last 27:10 in the evening, when my 12 years minor nephew, namely Bodogali. That's
You are saying, how old is Bodorani?
Actually, we have given 16. We have stated on paragraph 7, my lord.
Okay.
Actually, here they have written 12. God is of 16, 15 years. He is of 16 years. Both are minor. And admittedly, something matter, some altercation took place because of that, my lord. We have warned him several times. He did not listen to it, my lord. He stopped the education and now he is doing this type of things, my lord. So, Bodogali going to home across the embankment after playing with his friend. Below mentioned accused person gagged my nephew Bodogali, dragged him and took him to their house and assaulted him badly, thereby laying him unconscious on the ground with intent to kill him. On getting the information about the incident from one of the friends, when we arrived at the place of occurrence to recover my nephew, accused person attempted to attack us with lathi, dagger, etc. Immediately, all the village people arrived at the place of occurrence, intervened into the matter, and sent them away from the place of occurrence. Thereafter, we recovered our nephew from the place of occurrence and admitted him to hospital for treatment, who is yet to get sent. Register 307, basically. 307.
What was the
Lordship, we have received only the Beecher's summary, Lordship. And Beecher's summary, Lordship, discloses some head injury, Lordship. That is left temporal hemorrhagic contusion, Lordship, following physical assault. That is a Beecher's summary, but medical report is still awaited. That we have not received yet.
condition? Condition means
Our victim statement will be there, madam. In our case, girl statement also will be available. That's also called for. So ultimate 307 is not there, madam. And also something might have some happened. I think custodial interest is not required.
okay. Only 307 is the.
Yes,
Yes,
only
yes.
non-variable.
From the discharge slip, it appears that he suffered contusion,
Hemographic, hemo,
hemorrhagic.
hemorrhagic contusion following physical assault.
Now he has been discharged.
Yes, Lord. The church summary
Immediately,
yes,
madam.
we have received.
Just to make out a case, he was my lord hospital.
No, otherwise there was an assault.
Otherwise, he has been beaten up by several persons, Lordship. Basically, they have implicated two persons, Lordship, Delbar Ali and Anwar Hussain.
Father of the guard.
Petitioner number 3 and 4.
What is your submission?
Lordship, otherwise, the occurrence happens repeatedly. And Lordship, the mob attack was, he has been mercilessly beaten up by the persons, Lordship. And there are some eyewitnesses also that have gone to the statement of the eyewitnesses. They have indicated
No,
specifically
what?
both these two persons.
Okay, there is a mob assault.
Yes.
But at this stage, what is his condition?
Lordship, as per medical report, he has been discharged.
Medical.
Yes.
Show me the
Lordship, yes.
discharge.
See the discharge. Some. Hmm? Stop that.
Whole person already arrested now.
Arrested person.
6 to all are family members, sir. All the 10 are family members. Total 10% named in the FIR. That is father, brother's murder. Brother, son, wife, and 6 to 9 arrested, my.
And they have specifically indicated petitioner number 3 and 4 witnesses.
Delbar is the father of the girl.
Father of the girl.
And Anwar?
And Anwar is the son of Dalwar.
Dalwar.
Brother of the girl.
Brother of the.
Yes.
So they have assaulted more.
Yes. As per the witnesses statement.
Actually, interrogation, my lord.
Whether custodial interrogation would be.
That I leave it to your lord.
No, is there any? Okay. They have not yet appeared before the IO.
Lordship.
Heard Mr. H.R.A. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. A.F.N.U. Mullah, learned counsel for the petitioner. Also heard Miss S.H. Bora, learned additional public prosecutor. This application under 438 of the Code of Criminal Procedure for 1973 has been filed by the 6 number of petitioners, namely, write the name, namely so and so, who are apprehending their arrest in connection with Lakshipur PS case number 311/2023 under section 143/341/342/307/506 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 28/10/2023, one Azad Ali had lodged an FIR before the officer in charge of Lakshipur Police Station, inter alia, alleging that on 27/10/2023, the accused persons named in the FIR, within bracket total 10 numbers of accused persons are named in the FIR, had assaulted the minor nephew of the first informant, namely Badr Uddin and caused my caused
assaulted him that day, my lord. Who came to their house, assaulted.
caused injuries on his person. On the other hand, next up, Learned Senior Counsel for the petitioner has submitted that though there was an altercation on 27/10/2023 as alleged in the affair. However, the cause of the altercation was that prior to the lodging of the FIR against the present petitioner, the petitioner number 3, namely Delbar Ali, had lodged an FIR before the officer in charge of Lakhimpur Police Station on 27/10/2023 against 14 numbers of accused persons, including the alleged victim as well as the informant Azad Ali, wherein it has been alleged that the alleged victim, namely Badr Ali, used to disturb and tease the 15 years old minor daughter of the petitioner number 3, namely Delbar Ali. And on 27/10/2023, the daughter of the petitioner number 3 was attacked all on a sudden by the said Badr Ali, and she was dragged and thereafter an altercation took place. No, she was attempted to be abducted by the accused persons named in the affair. Learned Counsel for the petitioner has submitted that Learned Senior Counsel for the petitioner has submitted that there was an altercation, and that was only because of the fact that the said Badr Ali alias Badr Uddin had teased the daughter of the petitioner number 3. It is further submitted that there is no other dispute. Only
No, only this is altercation.
that the petitioners would cooperate in the investigation if they are allowed to go on bail. On the other hand, Learned Additional Public Prosecutor has produced the case diary of
Lakhimpur PS 311.
Lakhimpur PS case number 311/2023 and has submitted that there are incriminating material against the present petitioners, more specifically against petitioner number 3 and 4, namely Dalbar Ali and Anwar Hussain, to have assaulted the victim Badr Uddin. She has also pointed out that from the injury report, from the discharge summary of the injured Badaruddin available in the case diary, it appears that the injured had suffered head injury within bracket left temporal hemorrhagic contusion following physical assault and was treated conservatively by the doctors. However, she also submits that the injury report, apart from the discharge summary, no other injury report is available on record. She has opposed the grant of bail to the present petitioner on the ground that the victim has been assaulted by a mob, mercilessly assaulted by a mob in which he sustained severe injuries. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. It appears that from the materials available on record that there is an allegation against the victim also of teasing the daughter of the petitioner number 3 and the sister of petitioner number 4, for which it is not unnatural that some altercation would have happened. It also appears from the discharge summary of the victim Badaruddin that he was admitted in the hospital on 31/10/2023 and was discharged from the hospital on 4th of 4/11/2023, which indicates that he remained in the hospital for 5 days, and was provided conservative treatment. And at the time of his discharge, he was stable and no significant abnormality was observed in the condition of the patient/victim. Considering the fact that when the incident occurred, there are cross FIRs from both the sides, and from the materials available on record. At this stage, it appears that the victim has not suffered any grievous injury. Hence, and also considering the fact that the petitioners are ready to cooperate in the investigation. Hence, this court is of considered opinion that custodial detention of the petitioners may not be necessary if they cooperate in the investigation. In view of above, the above named petitioners are hereby directed to appear before the investigating officer of Lakhipur PS case number 311/2023 within a period of 10 days from the date of this order and cooperate in investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Lakhipur PS case number 311/2023, the above named petitioners shall be allowed to go on bail of rupees 30,000 each, with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is thereby disposed of. Send back the case.
Two cities.
Send back both the cases.
Yes.
May I, Lord? Lord, here, Lordship will find, Lord, the FIR at page 11, my lord.
What is your name?
My lord, Shakinur Islam,
How many petitioners are there?
2 petitioners. Shakinur and Shahidul Islam. Page 11 is the blood affair, their name. Now, rest accused person have been released on bail by this honorable court. We have annexed those order also. my lord. Some unknown miscreant, my lord, but their name is figured in the affair.
But in FIR, you are named specific.
Yes. Now, Lordship, kindly see page 25. The other accused who are also named have been released on bail by this honorable court. Page 25. And my lord, page 27, para 7, my lord, Lordship, my lord, finding. Page 27, para 7. Then, my lord, page 29, another, my lord, sets of accused person who are also named. They have been released on bail.
This is an BA. Since when you are behind the bar?
My lord, 43 days. And those person, my lord, who are released on bail, my lord, first one is, my lord, after 1 month, and second one is, my lord, 39 days, and third one, Lordship will find page 29, only 14 days on perusal of the case day.
Yes. Mr. Chair.
My lord, as my learned friend said, my lord, that page 25, this is my lord, accused my lord, Aminul Haq, my lord, is actually not the primary key. Primary key is my lord, the present petitioners, my lord. Actually, they are my lord 4 brothers. That's Shakinur Islam, then my lord Shahidul Islam, alias Bhutto, then my lord Hamidul Islam, and Rakhijul Islam. They are the 4 brothers, my lord. And my lord, this Sakinu role is that, my lord. He has entered in that room, my lord, of the deceased person, my lord, in the evening, my lord, and conceal himself. And at night, my lord, he opened the door, and my lord, these other 3 brothers, my lord, entered, and all of them, my lord, and killed, my lord, both husband and wife, my lord. And my lord, PM report is there, my lord. They are.
No, is there other material? There was is there any eyewitness?
No, my lord, this is happening in the night, my lord. No eyewitness.
Then how it is, how
From
you,
from the statement of some, my lord, some of the, my lord, neighbors and my lord, statement of
no,
some.
who saw them entering and
No, my lord.
nobody saw?
Nobody saw.
Then on what basis this statement is made? That
My lord, one of the, my lord, co-accused, he is, my lord, already arrested in another case, my lord.
co-accused has
My lord,
implicated.
yes, my lord. No, my lord, eyewitness is not there, my lord. Because at night, my lord, that room, my lord. But
Then
in the PM report, my lord, the
injury is there.
is there.
That is okay. But
Yes.
who is involved? Is the
And my
whether
lord, and my lord,
Shahidul
from the statement of my lord, witnesses, my lord, they have, my lord, long standing, my lord, land dispute.
so there is a genuine suspicion
That.
apart from suspicion.
And my lord, there was 164 statement of my lord, the son. My lord, may I please it for the lord, please?
Son of the deceased.
This is,
He has implicated.
my lord.
Whether he has seen.
No, he has also not seen.
No, any other circumstantial evidence that they
My lord. And there are some other 164 statement also there, my lord. And my lord, they said, my lord, that they were not in that village, my lord, on that day, on the 25th date, 25th date.
you flag the case diary.
My lord.
Flag the case diary.
Big, I will flag.
Go through the case diary.
My lord.
path on. Because other co-accused are granted bail only on the ground that evidence at this stage is not against them, though suspicion is there.
Yeah.
So if you can flag out anything, even a single material is against them, then we will consider.
My-
I'll go through the case.
My lord.
42 days in custody.
Okay. But for a 302 case,
Yes.
42 days may not be
But
only ground.
but the co-accused have already been released.
That may be favor. That may favor.
Obliged.
I'll go through the case. Then.
May I please, your lordship? My lord, with all respect, my lord, that case that you was sought for. Yes, my lord. Case that it will be. But here is the case, my lord, with all respect, my lord. Lordship would kindly have a look at page 10, that is the affair. The gist is this, my lord. The lady and her husband, my lord, who has alleged rape, my lord, with all respect, my lord. Lady's husband is to work with the present petitioner
at page
10, my lord. 10, may I just read it?
Yes.
Page 10, my lord. Lordship has found, my lord.
Yes.
May I read it? Most respectfully beg to state that the aforesaid accused is my husband. This is against the husband, my lord. Because 498A is there, my lord. The accused has been torturing me in different ways. This is as regards the husband. I am not involved at the moment, my lord. I have to pay the accused person by selling my body. He assaults me. The accused person sent me to Delhi with one unknown youth. He is me, my lord, before your lordship. And a said youth committed physical relation with me. The accused person took rupees 6 lakhs from the said youth. This is loan, my lord. Different matter, my lord. Once when he sent me with the said youth, namely Bhupen Deka, he is before your lordship arrested, my lord. The said youth committed physical relation with me for 3 days by keeping me in unconscious state. By sending me with Bhupen Deka to Delhi, committed bad work with me. On last night also, this is regarding the husband, my lord. He entered into argument with me. He only wants to engage myself in intercourse with Bhupen Deka for earning money. This is the case. This affair was lodged on 15/10 and they went to Delhi, my lord. I have annexed the tickets. Absolutely, my lord. Voluntarily she went. Page 21, my lord. Page 21. And that too, 9 months back, my lord.
Lordship has found page 21, my lord. This is a ticket from Guwahati to Delhi. The name of Bhupen Dekai is there, my lord. Date is 10th March 23. SC alleges in the FIR. Thereafter, I turned the page. The lady's name is there, my lord. Junu Begum, 10th March 23. Thereafter, the child went along with them, my lord. It is impossible, my lord. Page 23, my lord. 10th March, Jasmira Sultana, my lord. They went on 10th March and return back ticket is together. That is page 24 on 12th March, my lord. All three, my lord, came back together. So had there been any, my lord, ravished her without her consent, then there should have been an affair around 9 months back, my lord. Now there is an affair, admittedly, my lord, it was consensual if something was there. And a child was there in between. As alleged in the affair that she was taken to Delhi, it's a fact, my lord, they went together on volition. And husband was aware of it. Now 498A, tussle with
No,
the husband.
that is the allegation.
Exactly.
You were compelled, she was compelled to do this by her husband.
My lord, then she should have shouted in the plane, my lord. Then coming back, she should have shouted, my lord.
There may be other compulsions.
Child, my lord, 9 months back. It has happened, my lord. I don't know, my lord.
It may happen.
May happen, my lord. 9 months back, my lord. Now, if with her husband and she lodges, my lord. Whether my detention is necessary.
The allegation against you is under section 376.
Exactly, my lord.
Against you.
Yes, yes.
Against husband is
See,
that.
lesser degree. Lesser degree.
So let us see the case. then.
Yes, my lord, he was medically examined also, one person also recorded. Medically, nothing has been, my lord, found because it was done after 6 or 7 months. Once it was, my lord, will kindly pay it. Because yes, sir.
He has alleged. What is your submission?
My lord, 164 she herself is not sure, my lord, whether she was raped or not. That is clear from the 164 statement. That, my lord, accused person says that, my lord, he has committed rape. He has committed physical relationship, not rape. That's why I am, my lord, placing my lord.
Major lady, my lord, if there is something has to be consensual, my lord, 9 months hearing before. Any condition.
No. Mr. Parva, what is your
My lord.
submission?
My submission is that also 164 statement, he went with him, my lord. And
Yes,
her
that-
husband has dropped him. Husband has dropped her in the airport. Then husband said that I will not go, you go with him. Then she stays in a hotel.
He vanished.
Yes, she stays in a hotel along with her relative. He is along with her and minor daughter. Then relative in the night relative what I have my lord says, that is my lord, that is the incident. Against him allegation is 376.
My lord, arrested, my lord, not 430. 20,
How many days?
26 days. My everything is ruined, my lord. My
26 days.
business, family, business partner. So unfortunate.
But the allegations are also clear.
My lord, I cannot tamper with evidence.
I'll go through the case right. Pass the order.
I also, my lord, tag mark the husband's statement. He was also my poll party IO. His statement also record.
Pass the orders in favor.
My lord,
As on prima facie, look, I am not convinced,
Yes.
but I'll go through.
Yes. Well, can I just make a prayer, my lord? Kindly see in this situation, my lord, a trial stage, my lord. Occurrence.
The case is pending at trial stage.
No. I'm not saying that. You know what will happen, my lord? 9 months back, occurrence took place. No complaint in between.
Okay.
My
Whether
lord,
he's
lady coming
custodial.
back by plane, my lord. Together.
Okay. Whether his custodial detention.
Exactly,
would be
my lord.
necessary.
Harder, lord.
Other, my lord.
Okay.
And second aspect, my lord, another aspect, kindly see, my lord, that in this incident is the offshoot of a present fight on the date or 1 day prior to the logging of affair with
Between
her husband.
Husband and wife.
Thereafter, my lord, I came in because I visit the house every day. Husband visits me every day.
Still, let me go through the case.
My lord. Any
My lord,
condition, my lord, I
one item late, lord, item number 20, lord.
20, my lord.
Case ID received, my lord, but my lord, without the postmortem report, lord.
I beg apology, my lord. I could not hear. Is there PM report is not.
Without the PM report, my lord, he is
PM
in, my lord,
report would be-
capacity in that
would be
46
required.
days. My lord.
Now, what is your submission?
So my submission, my lord, the person died, lordship, they, both the person, the accused person and the victim, they consumed drug, lordship. Then probably, lordship, overdose, lordship, he died. There are statement also, lordship, that he was, my lord, he was brought by the, my lord, petitioner in a, my lord, quite senseless position, lord. Now,
Police
lordship,
report
only,
require senseless
only
position,
the
No,
postmortem
no,
report is
no.
not received, lord.
Not beyond court. We'll take it up as first item tomorrow.
tomorrow.
I'll pass orders tomorrow.
Well,
We'll take it. Item number 20. This is the last bail method. Miss
18.
H.M. Fukun, learned counsel for the petitioner, also Mr. R.J. Barua, who produced the case that, however, due to paucity of time, this matter could not be taken. Let this matter be listed for tomorrow. At what time you want?
Deputy, my lord, immediately after the motion, lord.
After the
Any, I do not have any objection because I have gone through the case there, lordship.
You are ready with?
Yes, lordship, because postmortem report is not there, lordship. Otherwise, my lord.
the first item.
Let this matter be taken up as first item after motion.
Lordship,
Tomorrow.
I beg
I
to
beg apology.
mention item 12, Lordship, which was the part heard. Any other day, Lordship, maybe on 30th November, Lordship.
Now dates you have to take from court master.
Lordship, please.
All same order. Due
I
to
pray-
paucity of time, this matter could not be taken up.
Lord,
My lord, though it is not reflected in the cause list, my lord, there is an order, my lord, from your lordship. Item number 12 and 13 are part heard, madam. So on 13th, my lord.
No, let me dictate. This matter could not be taken up for hearing due to paucity of time. This will be given by the court master. As per your convenience, take the date.
Lordship, please.
Subject to the availability of slots.
Lordship.